Chief guest, you know there's a problem. Good afternoon, ladies and gentlemen. Good afternoon, ladies and gentlemen. Good afternoon. So, I'm a firm believer in the presence of God and a firm believer in prayer. And since we are a country whose motto is for God and my country, we cannot start a session without prayer, even before I acknowledge that dignitary is present. I really do hope we are online. Are we online? We're online. Okay. So members of the bar who are online, humble yourselves for a word of prayer. I am going to ask, now let me look around. I'm going to ask, Doreen, would you mind leading us in a word of prayer? But when you come when you're not happy, I'm not sure the Lord will listen to your prayer. You have to be happy when you come to the presence of God. But if you're not going to be happy, tell me.
Thank you so much. Kindly let's humble ourselves for a word of prayer. Father, Heavenly Father, we thank you, Lord Jesus, for this great afternoon. Father, we don't take it for granted. Thank you for gathering us here. Lord Jesus, for your good cause. Thank you, Lord Jesus, for the entire leadership of the Uganda Law Society, entire leadership of the judiciary, and the government representatives here present, oh Lord. Father, we pray that you guide us, oh God, the deliberations that we are going to engage ourselves in, Father, to the glorification of your name. In Jesus' name I prayed, amen.
I'm sure you can say a louder amen. I know that she spoke using a mask. I know that she spoke using a mask, and you probably did not hear her. But you can still, of course, say amen. All right, now that we have dispensed with a word of prayer, allow me to acknowledge that dignitaries present. I will exclude the hosts for now. The Honourable Attorney General, we are happy to have you. Please do give him a hand clap. The Principal Judge, who is present with us here, thank you so much. The Director of Public Prosecution, who is seated right there. I'm sure she deserves a louder hand clap. When you're the first woman in that office. The Chief Registrar, who I must acknowledge, we are happy to have you. The registrars and magistrates present, thank you so much for coming. I think they're waiting for a hand clap. The Senior Counsel on whose shoulders we stand, we are really happy to have you. A representative from prisons, thank you so much. You are always available whenever we call. I think there are members of the bar online. I am told there are currently 515. This is what it means when there's an interaction between the bar and the bench. 515 members have logged on to ensure that whatever it is that we need to talk about today or repair, it is done. And the seriousness of the head of the bar here shows that there is something that we honestly need to talk about. And I think there are members of the bar in the house present. Mr. Muhindo, you're also welcome. And I think last but not least, allow me to acknowledge the council members in the house, Madam Secretary. I think this is the council where you hear enough madams. There's Madam President, Madam Vice President, Madam Secretary, Madam Treasurer. Madam Secretary, you're welcome. The Central Representative, who's also in the house, you are welcome. The CEO, who needs no introduction, Mr. Moses Okwalinga, is also here alongside his team. He's representing his team today. I am told that we are going to have an engagement today, and we're going to discuss many things. But our host here today needs no introduction. She's a woman of many talents, and also a woman who has traversed many parts of this country, giving the best of her knowledge. Not least of which is her leadership in the law fraternity. Ladies and gentlemen, allow me welcome Madam President, Mrs. Fiona Wall, to speak to us this afternoon. I am sure we didn't give lunch, but there can be a louder hand clap than that. We promise you there will be tea. There will be tea.
my Lord Justice, the Principal Judge, the Attorney General of the Republic of Uganda, Her Worship, the Chief Registrar, my Lord, the DPP, our past presidents, members of the judiciary and the bar present, and definitely not least, my council members. Let me recognize them. We have our secretary, Madam Rita Nangono. Please just wave to us. We have our council representative central, and of course our hostess, who's the vice president. We also have in the house our CEO and his team. Please wave to the crowd. And we have a representative from prisons. You're very welcome, sir. All protocol observed. Members online, we also recognize you, and any members of the Fourth Estate. It's with great pleasure that we welcome you today. Thank you so much. First of all, I hope you all had a happy Easter. And since this is the first time that we've all gathered since it happened, I'd like us to just take a moment of silence for our Right Honourable Speaker. Can we stand up and just... May his soul rest in eternal peace. Ladies and gentlemen, today is an important day. We've had a lot that has been happening around, and we thought that it would be good for us to have this conversation. We've had issues, just to hit the nail on the head, we've had issues of decorum, we've had issues of our bar-bench relationship getting really strained. And what is of utmost concern is that we also live in unprecedented days of social media. Information is instant. You say something and you cannot take it back at all. It's recorded. And then we also have a new generation. We have, they're called Generation Y or X. And this is both in the judiciary and in the bar. And yet we are a very privileged profession. We're the only profession that literally runs a whole arm of government globally. We also head another arm of government, which is Parliament. And I think that we ought to conduct ourselves, as somebody said, to whom much is given, much is expected. So today is really looking at the bar-bench relationship, at seeing how we can make it serve the people. Because at the end of the day, someone said when elephants fight, the grass suffers. The muntu wa wansi who benefits from the justice administration is the one that suffers when we do not work in harmony as officers of court. I want to thank all the stakeholders that are here, because we know that in all your departments you have various members of the legal profession who also sometimes serve as members of the bar, of the bench. Albert Pike rightly said that what we do for ourselves dies with us, but what we do for the world and others remains immortal. Today, as the people that are involved in the administration of justice in Uganda, we need to concern ourselves with these worrying trends. We know that lawyers are expected to show respect and reverence to the judges and refrain from disparaging remarks. We also have the issues to deal with, the bench and the bar assisting each other in the administration of justice. Both can make mistakes. How they should be addressed also reflects on both institutions. We also need judges to approach members of the bar with respect and to conduct themselves in a way and a manner that is worthy of the bench. A working and mutually beneficial relationship between the bar and bench is something both intrinsic and extrinsically valuable to the administration of justice. It has not only been social media, we've had so many complaints about how we treat each other in court and outside court, but we also have people that have contributed to these strenuous relationships, and these are people that work around us, the clerks in court and some of our own staff. We have, in the recent past, been working, and I want to thank our worship, on weeding out the fake lawyers, the ones that hold out. I think right now our registries are well aligned. Anybody that was not supposed to be in that system has been removed. But to see a lawyer with a practicing certificate behaving a certain way concerns us. My Lord, we have internal disciplinary mechanisms. The Uganda Law Society has a disciplinary arm, a committee, and I'm aware that the judiciary also has a committee. However, very many times our members have questioned the jurisdiction of these committees because they are legally established bodies, the JSC, the Judiciary Service Commission, and the Law Council that are supposed to deal with the disciplinary issues. But I think in a professional body, there should be some level of self-regulation. And I'm hoping we can begin this. We've been having various regional bar bench fora that have been successful this year and last year. But today we want to set a tone from the top. And I want to thank you all. Let's give everybody a hand clap for showing up. As the bar that represents members of the public before the courts, we need to ensure that our legitimacy before the courts is not questioned. We know very well what it costs for a lawyer to have a case in Law Council and the kind of backlog that we have there. Actually, I want to thank the Law Council in absentia that in the last 2 years we've been handling backlog, and I want to thank senior members of the bar who have been doing mediations. We've covered quite a lot of the backlog, but we still have a lot to do, and I'm sure that the Judicial Service Commission has the same problem. It's my humble appeal that today we shall have honest conversations. It's my humble appeal that today we shall also look at a way to deal with performance evaluation. There's a judicial scorecard, but we've been trying to work with the judiciary to ensure that it's 360, that it's not only judges and magistrates and being evaluated, but also the performance of advocates. We need to have open channels of communication where people can appeal to the chief registrar when magistrates misbehave, and where people can appeal to the CEO Uganda Law Society when they're being harassed or mistreated by our lawyers. So I want to thank our senior counsel present, our past presidents, President Sevgenyi and Dr. Diana Musoke. We want to glean from your experience. You've been leading this society for a long time. We want to hear from you. The head of the bar, we're very glad that you're here. You're a man of an accomplished legal career, and there are many young people online that look up to you. How did you get there without getting into fisticuffs with the judiciary? So I want to hear all this from you today. As a council, we're looking to you all and to those online for solutions. So keep giving us your questions. And without further ado, I would like to welcome her worship, my classmate. Let's give her a hand clap. Today she stepped out from her leave just to attend this. We really thank you for that, to come and address us. Thank you very much.
Thank you very much, the President. We can appreciate her as well. The Honourable Attorney General, my Lord, the Honourable, the Principal Judge, the Director of Public Prosecutions, the President of the Uganda Law Society, Senior Counsel present, distinguished members of the bar and the bench, both present here physically and online, members of the Justice, Law and Order institutions who are here, invited guests, ladies and gentlemen. Good afternoon. The president didn't give us lunch, so we have no energy, but I believe we can say hello. So President, next time we will start with lunch, and then we'll have all the energy for the afternoon. Thank you. It gives me great pleasure to be here this afternoon. And I want to thank the President, the Law Society, and your executive. Thank you so much for initiating and convening this very much needed engagement. And I thank you for inviting me. I must say it's okay to make the sacrifice and leave matters of leave and be here, because it's important to always receive feedback. That is the only way we are all able to improve and therefore serve the people of this country very, very well. So allow me to take this opportunity to thank all of us who have made time. The Honourable Attorney General and my Lord, the Honourable Principal Judge. This must also be your first engagement after leave. So this is how serious the judiciary takes it. So thank you so much for making time. And I want to appreciate all of us for coming from a long holiday to celebrate Easter. And President, what a way to start after the long holiday of Easter. Allow me again to say that this cause is worth all our time. It is worth all our time because there are matters we need to deal with, there are matters we need to talk about, and therefore I do not take the presence of everybody here for granted. And I'm happy with the online numbers. The last time I saw it was 565, and I guess it is growing, and that is really very good. The Bar-Bench Forum is a space where actors in the administration of justice have the opportunity, usually at the High Court circuit level, and the divisions to navigate through many rough terrains in the administration of justice. In such fora, communication is encouraged between members of the bar and the bench in a polite and very respectful manner. So what does the Bar-Bench Forum aim to achieve? One, to bring together members of the bar, the bench, and other stakeholders to discuss best practices for effective administration of justice. Secondly, such fora also avail us an opportunity to reflect on the critical issues of delivery of justice in this, our beloved country. Number three, this fora also enables us to discuss the challenges that face the different courts across the country. And lastly, through such, we are able to promote collaboration of all stakeholders in the administration of justice and recommend solutions to the challenges that have been identified in administering justice. I must say, as the Chief Registrar, very often I receive communication, some in terms of complaints regarding conduct of both advocates and judicial officers, and particularly of the lower bench. Allow me use this opportunity to appreciate such feedback. Some of this has helped me to keep some judicial officers in check, and I want to encourage all of you not to waver in bringing these bad apples to my attention. I also want to encourage you as well to bring forth credit where it is due. I think people have always said it's nice to thank people when they are still alive. It is nice to appreciate people for the good things that they do. I know there are many judicial officers out there who do an incredible job. So I would like to encourage members that as you bring the bad news, bring also the good news so that we can appreciate it in due time. In the same breath, I acknowledge and appreciate that many of you have been patient with the systems, particularly in the registry of my office when it comes to the peak season of the year, when it's a rush hour for securing the renewal of your PCs. I want to thank you for your patience. And also I want to say that some of you have let me know sometimes of the misgivings you have encountered in the process. And I must say that progressively we have tried to ensure that our services improve and that we also better the way that we serve you. So for those who have brought forth their issues, I want to say thank you very much, because everything that you bring helps us to improve. Each year we enroll close to 2,000 advocates. So this shows that the profession is really growing. And what does this mean for the registry? It means that we are very busy. The team is very busy. His Worship Alan is here. There are days they do not sleep. That in addition to the new entrants, we are also dealing with the older members who are renewing their practicing certificates each year. And sincerely, to say that the registry is busy is an understatement. There are days we say it's the busiest kitchen in the busiest hotel in the world. Things come and things have to go in the same pace. However, that is not an excuse for us. In as much as we are busy, it's incumbent upon us to continually consider how best we can make our processes more relevant and also be able to serve you in a very, very timely manner. So I must say, as a development, we are in the process of creating an e-roll for advocates, and this is going to help us improve and manage the storage of information relating to one's practice from the time an advocate enrolls. So I want to confirm to you, the President, and your members that this is work in progress and we are at it. If you want to clap, I think it's better to clap. Don't just try to clap. Thank you very much. So we will not stop until this is done. And we believe that this will enable us to be able to fasten our processes in the registry. And in due time, we are hoping that even the process of renewing, and we have discussed this with the President, that renewing of practicing certificates should be done electronically. We want to see the day when somebody does not have to move from Arua to come and renew their PC in Kampala. So that work is in progress, and we shall be happy on the day it is ready to launch it and to ease your business. So I must say again that notwithstanding the traffic in the registry, there are some trends that have been noticed, and it's important that I bring them forth to you, the members. At the time of application for renewal of practicing certificates, some documents such as the NSSF certificates and those where you show your CLE points, those that have been submitted, for some of them they have been forged. And some advocates are having also their clerks or other third parties sign for them in terms of signing their applications. And I believe this is a practice we should not condone, and also we must stop it. So these are the things I've brought to the attention of the President, and I want to thank you for your quick action on some of them. And I mean, all of us know how, prestigious the legal profession is. I think it's our role to all guard it from all corners very, very jealously. So President, I want to thank you for always responding when we have such issues. Other bad practices, because this is a door feedback, so allow me give some. Other bad practices are those where we have advocates appointed as commissioners for oaths, failing to gazette their appointments for a very long time in accordance with Section 1(3) of the Commissioner for Oaths Act, Cap 5. I think we all know this. So, Madam President, I appeal to you to encourage your members to ensure that they complete the process. So whereas I have noticed concerns I have with advocates from the perspective of my office, that is very briefly, allow me to say that I am no stranger to concerns against the judiciary. Over the years, there's been criticism of the judicial system, and we are not proud about it, and the complaints have varied. Some have been about the technical procedures, especially for the common man. The backlog is still with us. It's now in the range of 49,000 cases. Court processes are too expensive and only favor the poor. Those are complaints that have come. And also that judicial officers and staff of the judiciary are corrupt, and that the system is also too adversarial. There are so many of such complaints. But again, I can only say that all of us have a role to shape the courts. We all have the role to shape the judiciary that we all want to see. So certainly it is not the duty of only one side, but all of us combined efforts should be put together to change the judiciary, and I believe that such engagements will take us to where we want to go. So members, allow me to inform you, and you have heard this before, perhaps from the Honourable the Chief Justice, that the judiciary is on a journey to transformation. And following the enactment of the Administration of the Judiciary Act, The judiciary so far has made several strides to try and achieve its vision of justice for all. And part of this transformation agenda is that the Chief Justice has informed all of us as people from the judiciary and the country at large that his vision is to redefine case backlog from 2 years to 1 year, or 24 months to 12 months. And I believe that with the cooperation and collegiality from advocates, this will be attainable if we all work together. It will not help for us in the judiciary to catch the vision and run with it when you as advocates who are key stakeholders do not. So I believe that with members of the bar buying into the vision of the Honourable Chief Justice, we know that seeking adjournments unnecessarily and use of delaying tactics to defeat hearing of cases would be a thing of the past. So the role of advocates in the administration of justice and in the transformation of agenda of the judiciary should be encouraged, and once you embrace it, then there is no doubt that that transformation will be a reality. As we head to the transformation, you have seen ICMIS has come, and I am happy I received some of the comments that I believe there is time to respond. And I'll be introducing somebody who is critical to ICMIS who has also joined us here at that time, who will be telling you more about this system. However, today, as I bring my remarks to an end, allow me to implore you to think of members of the bench, that is the bar, as being in the same struggle with you. In essence, we are all in the struggle to dispense justice to those that we serve. So let it be said of us that we are all learned enough to find solutions to our problems in administering justice, as opposed to blaming each other in dispensing justice. Working together takes people further, and we have had instances where working together alongside members of the bar and the bench has definitely borne fruit and has been very insightful. For instance, I can tell you the issue of working together on the rules of procedure. We have worked together, the bench and the bar, and I think we celebrate such achievements together. So let us continue to work together. I know, therefore, without a doubt, that we can do better in the quest to administer justice to all the people we serve. We can bring excellence to our role as advocates, and in equal measure, being excellent as judicial officers or members of the bench. As we deliberate today on how to get there, I encourage all of us to take stock of where we are not doing well, but also focus with greater zeal on how we can do better. Owing to the importance of this engagement, it is imperative that a lot more time is devoted to us, hearing how we are serving as a judiciary the people of Uganda, and how we can sharpen each other as iron sharpens iron. Madam President, with the executive, allow me to once again thank you very much for convening this important engagement. Thank you so much for listening to me, and it's now my singular honor to invite the Honourable, the Principal Judge, to make his remarks. Thank you.
The Honourable, the Attorney General, Your Worship, the Chief Registrar, the President of Uganda Law Society, members of the bench and the bar, let me single out the senior counsels present. Madam, the DPP, sorry for breach of protocol. I think I should have mentioned you earlier. Distinguished guests, ladies and gentlemen, good afternoon. I thank you all for taking time off your busy schedule to participate in today's Bar-Bench Forum. I must admit that I think we've taken long without having the kind of forum. The Chief Justice has appointed me as the focal person for the Bar-Bench Forum, so Madam President and your counsel, I'm at your disposal anytime you want to have an engagement. I believe in this type of engagements. They are quite informative and very important. This forum is yet another commitment by members of the bench and members of the bar to streamline the relationship between the bar and the bench, strengthen mutual trust, bring out the challenges the bar is facing in pursuit of administration of justice, and find ways and means of revamping confidence in the administration of justice and the legal profession as a whole. I'm lucky to have belonged to both sides of the coin. I was a practitioner, so there is nothing you do that I don't know, including the bad practices. I know what you are capable of doing or what you do. And now I'm on this side. So sometimes you appear before me, I see you lying, and I know this is typical of anyway, jokes aside, the bar has for a long time grappled with allegations of corruption, inefficiency, and indiscipline. These complaints arise from the public, the bench, and even the lawyers. I hope that in today's forum, we shall find a lasting solution to overcome these vices. Both the bar and the bench alike define the public perception of the administration of justice. It is therefore of paramount importance that we work towards rehabilitating our image. Now, colleagues, I must tell you that there are certain things that don't change in professions. For example, in the army, you must respect your commander even if you think he's an idiot. When he orders, you follow. Now, in the legal profession, it's not that you must have the judge more intelligent than you. In fact, there is no such a rule. It is just a question of mutual respect. When I was an advocate, whenever a senior counsel like Sebugenyu would appear, even if my file has been read, I would inform the judicial officer that my lord, or your worship, senior counsel has come in. It would be okay if you adjourn mine temporarily and you first listen to senior counsel. That has nothing to do with whether senior counsel is going to present a better case than mine. It's just mutual respect. Now, the reason why we have that element of wanting judges to be respected is that orders of court should not be made in vain. They should, because when lawyers disrespect orders of court, then there is no reason why you should blame a DPC tomorrow when you take a court order and it says this is trash, because you have set a precedent as lawyers. So I think we need to, there are certain things that don't change in professions. I know when I was in academics, I studied something to do with the generations. Of course, you know, students can be very problematic. Every year that comes in, you have another group also becoming more problematic than the previous one. So the current generation is what we call Generation Me, and it has its own issues. So I was trying to compare the study done by Harvard with our own generations here to see whether we have similarities. I don't want to go into details of what Generation Me is, but I'm sure you must be grappling with that, even as advocates in your own chambers, with Generation Me. Maybe at another appropriate forum I will discuss that. So, comrades, what I'm trying to suggest is that let's have that mutual respect when you appear before a judge, even if you consider him to be of low pedigree. Just, you have nothing to lose by respecting. If he says, the counsel, I'm adjourning your case, you can say, my lord, maybe if you could consider this. If he says no, you adjourn grudgingly, you know. But you don't go to social media and say, you know, that judge is hopeless. He's an idiot. That can't be the legal profession. It must have that mutual respect to be able to command respect for the court orders we issue. Allow me recollect that counsel's duty is not only to his client, but extends to court and the society at large, whose overriding interest is ensuring that justice is done to all in all cases. In this regard, I implore advocates to view justice not as a one-way traffic, but indeed three-way traffic. Justice to the plaintiff, or complainant, justice to the defendant, and justice to the society. I think the biggest challenge we get, what I see normally when lawyers appear before me, is like when you are representing the plaintiff, you think justice should be done for the plaintiff only. But you are supposed to represent the plaintiff, but also look at the defendant's evidence and make sure that justice for the plaintiff is also done for the defendant. But we tend to have a one-way traffic when this should be a three-way traffic. Advocates are reminded that their fundamental duty to court during trial. An advocate should always display a dignified and respectful attitude towards the presiding judge, not for the sake of his person, but for the maintenance of respect for the confidence in the judicial office. An advocate ought not to engage in the exchange of banter, personalities, argument, or controversy with opposing counsel in court. I had a situation where two senior advocates actually abused each other before me, and I chased them from my court. It was unheard of, two advocates quarreling before a judge, because we always have ways of disagreeing. His objections, requests, and observations should in every case be addressed to the judge presiding in a respectful and courteous manner. I remember when we were at RODC, when we were studying professional ethics, they would say that even when you are disagreeing with your fellow counsel, you know there is this idea that when the counsel is talking, you sit. When the other one finishes, you stand and oppose. You don't shut up counsel. You don't. These are things we studied in professional ethics, but you see them always happening. His objections, requests, and observations should in every case be addressed to the judge presiding in a respectful and courteous manner. Allow me to point out some of the major concerns for the immediate attention of the Uganda society, which, if addressed, will go a long way in revamping the image of the profession. These concerns are categorized in three dimensions. That is, issues from the public, the bench, and the fellow advocates. These have been extracted from the numerous complaints I receive in my chambers. The concerns from the public, one of them is corruption. This is a buzzword, I think, in the judiciary everywhere. Some of it is perceived, some of it is real. And this goes, you know, advocates sometimes collect money on behalf of judges, and they are not aware. And then an advocate comes to your chambers, he says, "My lord, I have an issue." Then, like for me, who had, when I was the circuit judge, I had an open door policy. I would never fail to see an advocate if he wanted to see me. So now the advocate enters, and then he, with a small bag, and then he comes out and says, "Hey, I have given him." When definitely there is nothing. Some lawyers charge legal fees, and they say, by the way, you know, you are going to bring 20 million. But for me, actually mine would be 3. But that judge, without 17, we can't get judgment. And yet all of it is yours, you know. Now that is on the side of the advocate. But there is also the judicial officers. They are those who are crooks. In fact, I've always told them that, do you ever imagine that sometimes when you are sentencing someone, either for anything, theft or something, you should be the one on the charge sheet or on an indictment? We have those both sides of the coin. We can't, but there is the actual and there is also the perceived one, which I'm mentioning, where actually the judge is not corrupt, but somehow the lawyers make it like he is, through the example I gave. Then there is also withholding of funds received on behalf of clients. This is common with the lawyers, including senior ones, unfortunately. You receive money on behalf of the client, let's say compensations from my Honourable, the Attorney General here, and then you swallow it. And then they start another cause of action against you to recover it. Sure. Then failure to account for the clients, for the money paid. You see, a client pays you money, and then you start playing hide and seek, and there is no accountability. 3, failure to render professional services inadequate representation in court, and the lawyer's failure to appear in court to execute instructions after being paid. Now, you see, these clients, you know, I wish you knew how they take you to be very important. Now, someone pays you, and you start praying hide and seek. You can't represent the person. Then charging exorbitant fees, which deprives the poor and marginalized of access to justice. Now, we have the advocates remuneration and taxation of cost rules, which we use to charge these fees. The schedules are very clear. But sometimes advocates can charge as much as like in the marketplace where you appear and they see you in a suit, and then actually I think the vendors who work on the streets are the ones common in that the experts in that overcharging. You can ask a vendor, how much is that bottle? He says 20,000 when it is actually 1,000. So he knows that a serious person is going to start at either 5 or already when you start at 5, he has already made a profit. So I don't think we need to charge that way. We need to be modest in charging fees. These are the complaints I always receive. I'm listing the complaints I receive from the public. Then conniving with errant bailiffs frustrate due process in the execution. Then we have concerns from the bench. Of course, there are many. I just picked a few. Then we have concerns from the bench. One, members of the bar swearing false documents and forging court documents. Really, advocates forging court documents? Backdating them and smuggling them into files? We've had to discipline one of the cracks. So now I don't know whether the advocate should not follow suit, because if you bring a document and backdate it and have it on the file and try to even influence the entry into the register, which is already, why shouldn't actually such a lawyer be arrested? Blatant refusal to stick to the timeline set by law and issued by courts. Sometimes you give lawyers timelines and they do not comply. Sometimes which is to the disadvantage of the client. Number 3, treating members of the bench with respect and publicly ridiculing them on social media and other forums. Even if an advocate has personal grievances against a particular judicial officer, it is of paramount importance that the right channels are followed to address the grievances, other than publicly ridiculing him or her. Like I have already highlighted, this serves to maintain the confidence of the public in the judicial office, which that particular judicial officer occupies. I think I've already dealt on this. I don't need to repeat what I dwelt on. Then you have courtroom decorum. While the court is in session, it is improper for an advocate to assume an undignified posture, and without the judge's permission, remove his or her gowns in the courtroom. It is equally improper to be attired in any apparel or ornament calculated to attract attention to himself or herself. You know our attire, which we are supposed to put in court. Now, if you want to come in like a DJ, that's a different profession. Now, blatant contempt of court orders. Contempt serves to insult or resist the powers of the court or the person of the judge who presides here. There, consequently, gross insolence against the orders of court or direct opposition to advocates plainly tend to create a universal disregard of judicial authority, which in turn ripens a ground for public disregard to the same authority. In the end, you have a society full of anarchy. The moment we don't obey court orders, the moment we disrespect judicial officers, you know that very soon you will have no business. I must state this because I was an advocate. The moment you don't respect court orders, as lawyers, do not expect the public to do the same. Do not expect police to respect those court orders. Forum shopping, which has recently become a big problem, we need to get an appropriate punishment for this. I've seen lawyers filing cases, you know, he just comes to Kampala and files the case here, and the subject matter is for Guru. So, I mean, or the matter is for Kampala here, he goes and files it in Jinja. And then you receive complaints, you have to do the transfer of files. I think that sometimes can be a little bit problematic. Then we have a problem of filing multiple matters on the same subject in different divisions and circuits. I've had to convene meetings where I get heads of divisions to agree on who to handle files. You find someone files a case in a family division. It's a matter involving an estate. The third person comes to civil division and files their matter. The same person files in land division, the same person files in the commercial court. We are trying to find a way of getting an appropriate punishment for such advocates. Because that is, of course, the objective is simple. If family division declines an injunction, he gets it, in, maybe possibly civil division will grant it. Or if civil division declines, maybe land division will grant it. It's chaos. And I think we are trying to get an appropriate punishment. So that an advocate of such nature, if we consolidate, you either don't get costs in everything, or we order you to pay costs if you lose the case. Yeah, and I know lawyers fear costs. You fear to meet costs personally. So I think we need to sort this out. That is indiscipline on the side of the advocates. Then we have concerns from the advocates. Now this is us. Taking a course of action calculated to delay justice. It really saddens me to see advocates filing endless applications and documents which they well know are calculated to delay the trial. Now, you know, there is this idea of filing a matter, not because you think it is meritorious. You just file it to delay justice. This is common with, you know, matters to do with, let's say, mortgages, you know. You file, you just want to extend your payment period. So your objective is not really to get justice. You just file. So, and then that is followed by endless applications. Now, of course, this comes to us because the judge is supposed to take charge of that, and if you realize that really these applications are intended for a particular purpose, then you start taking appropriate actions, including, by the way, punishing the advocate, as I mentioned. Intentionally misquote, the advocates who intentionally misquote contents of a paper, a testimony of a witness, the language or the argument of opposing counsel, or language of a decision, or a textbook, or with the knowledge of its invalidity, to cite an authority, a decision that has been overruled, or a statute that has been repealed. This may many times serve to make otherwise simple matters complex and prolonged. Now, we have, of course, now this comes to the judicial officer in the sense that as a judicial officer, you need to be the one to sieve these aspects. But then it also goes to the advocate. Why would you, for example, cite a non-existent authority? And you know it's not there. We used to do that when we were terrorists. Maybe that's where the habit comes from. Whenever in your mood, your professional advisor would ask you, what is the authority? You would say, in the case of Musoke versus Sebugenyi. When it doesn't exist. Now, so I think that was carried forward too. Then we have judges and magistrates who you know you are not going to be at the station. And you just go. You have not informed the advocates. An advocate drives from here to Arua and finds the judge is in Kampala to attend a conference. I don't know whether we really appreciate how nauseating that is. When I was the circuit judge, even if I was sick, I would inform advocates. I think if there is any of you who ever drove to my circuit and found I was not present and is not aware, then the problem would be on your side. I would send the information on Uganda Law Society website, which I think is easily accessible to all, so that you don't drive to my circuit and find I'm not there. Because a lawyer, the time is money to a lawyer. Then we have also a problem of some judges and magistrates fixing cases, 10 cases at a go, and you all appear at 9. Then you see some advocates who had some little more over the weekend sleeping in court, waiting for their matters to be read. Sometimes you read, the clerk reads the matter, and then the counsel is asleep. Then they say, hey, counsel, it's your matter. Oh, then he jumps. Because you have made them come to sleep in your court. And yet matters must be phased. If you know this matter is long, you give it the whole morning. If you know it is so that lawyers don't come and waste their time in your court. Unless you have not practiced, then you don't appreciate the importance of time to an advocate. So I know those are some of the challenges. So to have a sound bar-bench relationship, I'm mindful that the bench ought to act with independence, impartiality, integrity, propriety, equality, competence, and diligence. Now we need to reflect as judicial officers whether we actually adhere to these principles. And as advocates, when we don't adhere to these principles, you need to let us know. The challenge I have found is that sometimes advocates, advocates come and complain. They say that judge is actually crook. They even tell you incidents, and then you say, if I take him on, are you able to come and testify? Then you hear the advocate say, no, I don't want it. Then you wonder really. You are telling me an advocate is a crook. A judge is a crook, but you are also not ready to come and testify against the judge. So what should I do? Surely. I think, you need to inform us whether we are adhering to these principles. That is independence, impartiality, integrity, propriety, equality, competence, and diligence. Because those are our obligations as judicial officers. The bar has often raised the complaints against judicial officers. Commonest among the complaints are delays in delivering rulings and judgments. This one is actually a common problem. I know of situations where we have had judgments delayed for more than 5 years. And this is a fact. I'm not going to mention names here, but I think I've had those situations where you find a judicial officer has delayed judgment for 5 years. That is unacceptable. Delays in adjudication of cases and long adjournments. Then misuse of judicial discretion. Then delays in processing records of appeals and absenteeism, etc. Absenteeism is a common problem, especially for upcountry courts. I've received complaints where some courts actually work on 3 days, and the rest of the days the judicial officer is absent. Recently, I saw a complaint where a judicial officer, I think, wrote and said, I will be away for 4 days attending the burial of Honourable Oranya. Can you imagine? Are you a member of the family? 4 days? Even if you were, that's not how you run a judicial court. But incidentally, there was a complaint. And the lawyer attached the communication from the judicial officer. He was not even shy to mention that he would be attending 4 days. Okay, then of course, in order to deal with some of the challenges, the judiciary embarked on a massive recruitment of judicial officers in a phased manner starting from last year, with the aim of reducing the case ratio per judicial officer so that in the end, cases can be heard and disposed of quickly. One of the challenges we have been having is case backlog. But it will soon be a thing of the past, given the adequate number of judicial officers and other interventions such as small claim procedure, electronic court case management system, pre-bargaining, daily hearings of criminal cases, and making funds available so that the sessions can be conducted in time. Of course, this will also depend on whether you give us information. As advocates, you appear before these judicial officers. Now, you go to Arua, and you find the judicial officer has not been at court for quite some time, and you do not have the courtesy of writing the chief registrar and say this magistrate so and so has been away for quite some time. So you need to, this is your court. It's your garden. It's your banana plantation. It's your ranch. You should not accept judicial officers, making your business difficult in particular areas. I know some of the areas we may not go there, but we are trying to devise means of monitoring some of these judicial officers. For example, someone who is in Kabong, you may not find it very easy to drive to Kabong and find out whether he's at the station. But you can use WhatsApp and you can say, Your Worship, are you at court? Yes, I would like to look at the veranda of the court. They told me it is cracked. Can you stand near the veranda and have a look at it? And if he tells you, my lord, I'm in the field, then you know this one is not there. So we can use it, and then of course we shall improve inspection. We are trying to have inspection regionally, so that you at any one time, you have a judicial eye monitoring what judicial officers are doing in the field. We hope that that should be able to solve some of these problems. In this financial year, we operationalized many magisterial areas, and I think within this coming short period, we are going to have more chief magistrates, so that we have chief magistrates everywhere. In the past, we had chief magistrates running more than 6 magisterial areas. I went to Fort Portland and I found the chief magistrate then was running 6 magisterial areas. Actually, he was a tourist, because before every day he would dedicate it to one magisterial area, but remember, a week has 5 days. So there would be a day when he would skip the other one and then go to, and yet he had his own station. But now I think that is being solved. So if we have chief magistrates everywhere, and then we have, in the next financial year, we shall operationalize a good number of high court circuits, and further operationalize a considerable number of other magisterial areas. We have high court circuits which are not operational. That is Moroto, Tororo, Iganga, Hoima, Ruwero, and Rukunjiri. So when we get judges on board, we shall operationalize them. So we think that should ease your challenges in some of those areas. Efforts are already at an advanced stage to decentralize the Court of Appeal to major regional cities. All these interventions would solve all concerns of delay in adjudication of matters. Additional efforts are underway to decentralize the inspectorate of courts, equip it with more human and capital resources, in order to strengthen the inspection in all courts with a view of stamping out all ills that court users complain about. In the end, our primary duty as a bar and a bench should be to work diligently, effectively, honestly, and sincerely towards achieving justice for all. This will be better achieved if there is mutual trust and respect between an independent and honest bench and a strong and a vibrant bar. I emphasize those two. So we need, incidentally, there isn't anything like we are, because I'm a judge seated on this side, I'm more important than you. Short of that, it's only that we are on different divides and we play different roles. So we actually play the same role. That is administration of justice. So I think let's have a honest bench and a strong and vibrant bar. And in my view, when we achieve that, then all these problems will be the thing of the past. Of course, human nature will always have problems. We cannot solve them completely, but we can significantly reduce them. And let's reduce the animosity between the bar and the bench. It's not necessary. Otherwise, you will be affecting it's like going to your banana plantation and cut all the bananas and go home. And you think you have done a great job. Thank you so much. Thank you so much.
Thank you, my Lord. Honourable Minister, Acting Minister of Justice and Constitutional Affairs, before you entered, we had given them lunch. So we expect a bigger hand clap. We had given them lunch and we even promised them tea right after this. So I am sure their hand clap is reflective of the lunch we had given them. My Lord, thank you for your interesting observations as well as your concerns. I can see that a number of members of the bar have reacted. They were hoping you'd say something about ICMIS, and I'm hoping that we'll have a conversation about that. Your Worship, the Chief Registrar, the biggest questions coming to you about PCs and renewal of PCs, but they're also commending you and the Uganda Law Society for ensuring that PCs at least have, there's more communication coming out from the judiciary as well as Uganda Law Society. We will share these questions later on. Allow me acknowledge the presence of the Acting Minister of Justice and Constitutional Affairs, Honourable Uls Bar-Bench. That is reflective of the lunch that we gave. Also allow me acknowledge the presence of, I was about to say Honourable, but Major Dr. Tom Magambo, who is the new CID Director. Thank you for coming. Whenever we see uniform in a place, we are sure that we are secure. So thank you for coming. You recently welcomed us into your office, and we have the privilege of welcoming you into our society alongside your legal team. Thank you for coming. We have had different bar and bench engagements throughout the parts of Uganda, at least the eastern region had, as well as the western. So we'd like to commend the judiciary for affording us the time and that you continue to afford us. I have to also acknowledge that the members of the bar are very interested in this. We currently have 863 members online, 863 members, which shows that we are extremely interested in our relationship with the judiciary. We understand our mutual need to work together, to respect one another, and to build a very strong bar and bench relationship. We are live on Facebook and we are live on Facebook and on YouTube. Let me just mention to members of the bar, if you send your chat in the if you send your comment in the chat room, we may not be able to see it. Please use the Q&A section. Now, I know for lawyers it might be difficult to understand this, but look at your gadget again. There's a small icon that has Q, there's a symbol of and then there's A. Use that particular portion to send your question so that we can capture it. If we capture it, we'll be able to address it in the room as well as help you. The chat is full of your names and your law firms. I'm not sure if you're advertising, but either way, please use the Q&A section to ensure that we capture your question. The judiciary has said we are a work in progress, or they are a work in progress. We welcome that. We welcome that, and we are hopeful that through this engagement, we might find a way forward. Allow me welcome the Madam President, who will welcome our next speaker. Please give her a hand clap as she comes.
Our Honourable Minister, you're very welcome. Also our Director CID. We want to thank the Director CID for helping us recently when we lost a member. That quick result from the police, I think, for us said something. Let's give it a hand clap. Also, as partners in the administration of justice, we have, of course, Madam, my Lord, the DPP. And I think we've made frequent appeals to you, especially when it comes to the administration of justice. We have some real challenges, especially on prosecution of some matters that are before the Constitutional Court. I hope that during this time we'll be able to, because this is also something our members have been agitating about, to give a little background we have, and I hope the head of the bar will also address this. We've had many cases that are being prosecuted on the Computer Misuse Act, and yet we are before the Constitutional Court. This causes real challenges for us in practice, and I hope we'll also deal with some of those. My Lord, thank you so much for your remarks. I'd like now to invite the head of the bar, the Honourable Attorney General, who I hope will also speak from the side of the bar as he addresses us. Thank you very much.
You can see how the president is trying to twist me. Yeah, Honourable Minister, Murui Mukasa, the Honourable Principal Judge, Honourable, my Lord, the DPP, Chief Registrar, representatives from prisons, representatives from Uganda Police, members of the Law Society, our partners from Law Council, civil society members who are present, ladies and gentlemen, members of the legal profession, senior counsels here headed by our erstwhile President, Uganda Law Society. Now, see, I'm trying to distance myself from that side. Ladies and gentlemen, I sincerely welcome you all to this annual Bar-Bench Forum. I must say that this is my first Bar-Bench Forum. All the years I've practiced, I've not attended any, and probably today, because I can say something, I will tell you why, especially because the judges are here. This forum creates an opportunity for interaction and exchange of views among judicial officers and legal practitioners on different parts of the country. Legal practitioners and the judiciary are like the left and the right arm of justice. It is impossible for you to run if both your hands are tied or one of them is not moving. That's what propels you to move forward. So we must always remember that the bar and the bench must work together in order to achieve justice. The main objective of our judicial system is attainment of justice for all parties involved in the case and the society. The bar and the bench are indispensable partners in the achievement of this objective. With the judiciary at the top of a strong and vibrant bar and complemented by it, there can be no failure. There must be mutual understanding and respect between the partners. It's like a marriage, husband and wife, judiciary and the practitioners. We are together, we are in this together. There is no way you can achieve justice without that. We must be mindful. You see, first of all, we talk about bar bench. Why it's so important here is that lawyers practice a lot more than what is done in court. We have people who are dealing in banks, we have people who are dealing in this, but litigation is the face of legal practice everywhere in the world. And we must be mindful for the purpose for which people go to courts. This is very serious and important business. There's an American jurist called Felix Frankfurter who said, litigation is the pursuit of practical ends. It's not a game of chess. It is serious. People come to courts for practical reasons. It's not an academic exercise. It's not a fanciful exercise. They are not playing. When a person walks up to the court, there's something serious they're trying to deal with. Each partner has its own duties, which if faithfully and professionally, diligently and effectively performed, will enable the system function optimally. The failure by one partner to perform its duty will naturally affect the other. Thus, the principal duty of both bar and bench is to work diligently, effectively, efficiently, honestly, sincerely towards the achieving justice in polity. This is the duty we owe both society and each other. We must always remember when we talk about the bar and the bench, I don't know, when you talk about justice, you talk about the two entities together. A failing in one will invariably affect the other. So we use this bar bench forum, this litigation is the most public way of exercising our practice. You'll never see the opinions we write to our clients. You'll never see them because they are from me to the client. The only time a person is going to see a lawyer at work is when they actually see them in court. So as we go out there to do this work, what we do in court, members of the bar, what we do in court, members of the bench, what we do in court is exactly what the entire public will see of us. The principal judge did speak about the duty. It's not only to your client, it's to the court, it's to society, but more importantly, it's to the law. Your duty is to the law because you are an expert in the law. So everything you say must be based on the law. We've been having a major internet bust up with lawyers and etc. over this coffee agreement. So when they asked me, I said, yes, I looked at the agreement, I signed it, I approved it. It doesn't breach any law. So someone asked me, but the economics of it, I say, what do I know about economics? What am I supposed to do? What is my duty? And we must remember this as lawyers. Our duty is to the law. You must read the law, and whatever answer you give must be backed in law. So that is our fundamental duty as the bar. It's the duty of a lawyer to maintain, towards the court respectful attitude, not for the sake of the temporarily incumbent of the judicial office, but for the maintenance of its supreme importance. The principal judge has spoken about the supreme importance of the courts. You disrespect the courts, people won't respect the courts, and eventually we'll have chaos. But respect is earned. Respect is not demanded. The court can't demand respect from me. The court must earn it. You cannot demand from the public to respect you as lawyers. You must earn it. Therefore, the way you earn respect is the way you'll be held. And respect, simply put, is a feeling of deep admiration for someone elicited by their abilities, qualities, or achievements. That's what respect is. A person looks at you, respects you because what you do, how you do it, how you did it. You're not going to be respected if you're standing on the table talking to each other while screaming. It's not possible. Because the person outside will look and say, look at this, the judge and the lawyer. These people, are they normal? They're just shouting at each other. Who is listening to the other? You must earn this respect. But we must remember as members of the bar that judges, not being wholly free to defend themselves, are peculiarly entitled to receive the support of the bar against unjust criticism and clamor. Where there is a proper ground for serious complaint against a judicial officer, it is the right and the duty of the lawyer to submit his grievance to the proper authorities. In such cases, but not otherwise, such charges should be encouraged and the person making them should be protected. Like the principal judge said, please, don't come to me and tell me about a corrupt judicial officer if you're not ready to back it up. Keep it to yourself. Because it is not helpful for you to come and say, I know that judge or that magistrate is corrupt, but you're not ready to come and give the evidence on that. We must protect the judges because they do not have the ability to come and speak out for themselves. A lawyer should be punctual in all our court appearances, and whenever possible, should give prompt notice to the court and to all counsel in the case of any circumstances requiring his tardiness or absence. I just don't understand how you can plan to be in court at 9 and you come in at 10. It's not possible. I don't even know why the judge would entertain you. If I were a judge, that would be gone. We must be punctual. We must be punctual because, again, it affects our clients. Our clients get to the courts before us. They wait. At 9:30, they start panicking. They get pressure. You walk in at 10. And then when you walk in at 10, you speak all these whereas, who, and what, and what. You finish all the Latin you can speak that day, every maxim you have, and you walk out. And then 1 month later, the judge dismisses your case. The client is going to think you are corrupted. You are late. He didn't understand what you're doing. You didn't have an opportunity to talk to them. You were in a hurry, jumping in and out. At times, the judge is also telling you, and so that cannot be respectful. A lawyer should make every reasonable effort to prepare himself prior to court appearances. I never appeared before any judge without my submissions written, and I'm not by any standards an unintelligent person. But you have to prepare yourself as a practitioner. You have to prepare yourself. And if you prepare yourself, you'll earn the respect of the bench. When you appear into the court and the bench realizes that this person has prepared themselves to do their work, you will earn the respect of the bench. And when you earn the respect of the bench, they'll start listening to you. But if you come to the court and you don't seem to be ready, all the time you're flipping through your pages, the judge is asking you, can you please, have you read your plaint? Yes, what does it say about this? And then you start flipping through your own plaint. That would not work. A lawyer should see to it that all their documents are required to are filed promptly and properly and honestly. If you're late, it's easier to ask for your document to be filed late than to try to push it into the file. Just write to your colleague. He refuses, go to the court. I was late. Why was I late? I was tardy. All that day I made a mistake. The court would be much easier to listen to you than if we start arguing about whether you filed on time or did not file on time. The relationship with judges, the lawyer should never show marked attention or unusual hospitality to a judge, uncalled for by personal relations of the parties. He should avoid anything calculated to gain or having the appearance of gaining special personal consideration or favor from a judge. You may know the judge because the principal judge was my classmate. We were in school for 4 years. The DPP was my classmate. We were in school for 4 years. But once I enter his courtroom, he's no longer the person I was with in school. Familiarity breeds contempt. Don't. Respect them. They are that side, you're this side. Do what you have to do. Don't say, oh, you remember when we met last week? What are you talking about? That's not business for the courtroom. That's not business for the, but remember, when the litigants see you doing that, even if there is nothing untoward about it, the person who doesn't understand that you're in school and you've known each other for 4 years or 20 years or 30 years will think that there's something untoward about their case, especially if they fail. Because it's a possibility. During the trial, lawyers should always display dignified and respectful attitude towards the judge presiding, not for the sake of his person, but for the maintenance of respect and confidence. I don't know how many times I've lost cases. I don't know how many times I've been angry. I have kicked the doors in my office. But when I stand before that judge, I'll put on a smile, say most obliged. I don't agree at all with what the judge has written. I'll say most obliged. I'll be so angry. I'll enter my car, I'll drive away and go and come back. That's all you're supposed to do. You cannot get out as a practitioner and start determining the intelligence of a judge because he disagreed with your view. Save where opposing lawyer fails or refuses to attend, and the judge is advised of the circumstance. A lawyer should not discuss a pending case with any judge trying the case unless the opposing lawyer is present. It's not worth it. Just let the judge be. As long as the lawyer is not there, don't discuss the case. Except as provided by the rule or order of court, a lawyer should never deliver to a judge any letter, memoranda, brief, or other written communication. And like the principal judge said, it's these things that we do that create the problem. You walk into the judge's chamber, you're walking out, you have a case going on, you're not writing to your colleague, and then there's a story going around that you have collected 200 million for the judge doesn't know what you're doing. So it's just these small things that we do that cause us the problem. A lawyer may submit to a judge any reason for expediting or delaying the decision. You know, I'll get back to that when I think, but let me first discuss the common complaints that we have. And the principal judge has so ably, and the chief registrar laid them out. Receiving money on behalf of judges, that's a very serious problem, and it is real. And the judiciary and the bar must do everything humanly possible to fight that. I don't know how we are going to do it, but it is true. Some practitioners do actually hold out as having interacted with the judge, and the judge has no idea what is going on. It's true. Even I in my office now, there are some people who have seen me. The other day, someone was complaining about a decision that I made which was contrary to what he believed he had paid for. So I said, now imagine if I had given the opinion in his favor. Everyone out there, the gentleman would be sure, this man received money. It was delivered. I was oblivious of what was going on. I wrote the opinion on the basis of what I knew, and the person wasn't happy. When someone said, I gave this man, I said, please, you tell that person, if he told you who gave him, where I put them. So we do that. And practitioners, we need to stop that. It's going to kill our profession. So the experts in AG work, we have experts in the legal fraternity who are just experts in attorney general work. That expertise needs to stop. That expertise needs to stop. I've gotten to a point now where, for me, I don't want to meet lawyers. I just want to call me and say, no, please write. Just write. Just write, we'll send. Because it's difficult. And we cannot operate in a society such as that one, where we are distancing ourselves from the people whom I should be engaging with on a daily basis. I should be able, just like a judge should be able, to pick up the phone and say, there is a lawyer who might not argue the matter of this nature, and say, senior counsel, there is an authority you provided to me 5 years ago on a matter similar. I'm doing some research. But if we create this relationship where we can no longer engage as part of the judicial system, then we start distancing ourselves from each other. It doesn't help us at all. But, my Lord, the principal judge and the chief registrar, there are actually problems, real problems, on the judiciary side. I said I've never attended a bar-bench forum all my years because, and like you said, even the lawyers will find it very difficult to say certain things directly, especially in spaces such as this one, because of the very nature of what our work is. The person who holds the decision on whether I will survive or not is the judge. So they will dare not say what they should be saying. But there's actually some real cases of corruption. The problem with corruption, as the DPP will tell you, is that it is not the kind of thing that is done ordinarily. It's a very complex kind of offense to deal with. But I am sure if you look around, you would wonder how a judicial officer has establishment 10 times what his salary could be in 10 years. You should check that. It is a concern. There's real corruption, and real corruption which is really sophisticated, where judicial officers use law firms to conduct these activities. But because the participants will never come to tell you, we have that problem of what? So we need to introspect and get to that. You mentioned the issue of misuse of judicial discretion. That is now the most sophisticated thing, because this person has discretion as a judicial officer and is independent, and this judicial officer will clearly misuse it. Clearly. Give an injunction, an interim order which lasts 2 years. It's impossible to say that that's not a corrupt activity. Okay, if you did not even get money, it's corrupt in itself that you issued an injunction as a judicial officer, an interim injunction which has remained on the file for 2 years. That in itself. Because we will talk about the corruption of receiving money, and we spend so much time on that. But the corruption of failing to do that which you are supposed to do, I think for me, is even a much greater corruption. Timekeeping in courts. For me, timekeeping in courts is one of the things that utterly shows how disrespectful the bench can be to the bar. That is a problem. You sit at the courtroom, and this person walks past you hurriedly at 9:30 when you are called at 9, and doesn't even have the common courtesy to say, I am sorry, I'm late. We're going to get problems, because I'm going to go away upset. I can't tell you, it is your court, but that needs to be addressed. If courts start at 9, let them start at 9. And we know the judicial officers, we know them even, that, oh, that one's 9, no. You can get in at 10, it's okay. That one is never going to be there at 9. Then we know those who say, it's 9, it's 9. And 9, you must be ready to start. But that's easy to find out, Honourable Principal Judge. You've talked about the delayed judgment. I don't think I can say more about that. Anything past 6 months, on a judgment is a problem. But more importantly, a case stays in the judicial system for 14 years, 10 years, and then you order one party to pay interest from the date of filing. Whose fault is it? A person filed a case against the Attorney General in 2015. Judgment is delivered in 2022, and you order us to pay interest from the date of filing in 2015. Whose fault is it that has been in the judicial system for 7 years? So it's really something that we need to look at, delayed judgment. But then there are also simple rulings. Simple rulings. Leave to amend. You return for ruling. I will come back to you, ruling on notice. We see these things and we wonder, is this judicial officer serious? You're going to come back ruling on notice on an application to amend? Then we have some cases of judicial officers not listening to advocates. That's very dangerous. Where a judicial officer comes and says, yeah, I want you to do this and address me on this point. It's perfectly legitimate. It's perfectly right. That's the court style. But it's dangerous because the public doesn't understand. So when the public comes to complain, we went to the judge didn't even hear us. He didn't even allow my lawyer to speak. To me, I understand exactly what that meant, because the judge, what are you going to tell the judge about an injunction? He knows, I've read the affidavit, I've read this, but you need to explain. The judge needs to explain to especially the litigants what is going on, because that block of information leaves the litigants totally unprotected, and that's why they come up and say, I think the judge was compromised. He already came with a decision. But half of us know that is the correct decision. Even when we are filing the applications, we probably believe that application can't survive. No judge is going to grant it. But we need to explain. So courts need to listen to the advocates, and more importantly, the litigants. The litigants need to get to know what is going on, because they are left out, and that for us is creating a huge problem. Because people come to us now, especially in Attorney General's chambers, complaining about this, and you have to sit through the process of explaining to them that you must not speak every time you're in court. The issue of written submissions, they don't understand it, and we lawyers don't even explain it. The judge says, I've given you a schedule, file on this day, and you get out. So the person says, the judge didn't allow us to be heard. So the court needs to protect itself from that, because we, the lawyers, have failed to do our job in explaining to the litigants what exactly these processes are. So ultimately, being stewards of justice means that as the bar and the bench, we need to do all that we can to ensure that the doors of justice system remain and are kept open. It's human to err. We're all going to make mistakes. We're going to make mistakes, especially because as lawyers and as judicial officers, yours is to determine the interpretation of a law. So you can be wrong. It's human to err, but let it not be fraudulent. Let it not be fraudulent on the part of the bench. Let it not be fraudulent on the part of the bar. Our courts must be places where people can come to seek redress without fear that they will be treated unfairly or disrespectfully because of race, religion, gender, disability. Good stewards of justice fight for access to the legal system. Justice means, simply put, the ethical, philosophical idea that people are to be treated impartially, fairly, properly, and reasonably by the law and the arbiters. That's what justice is. All this person expects to do is to receive fairness. Fairness. Even if he loses, he just needs to receive fairness. And this fairness must be seen and must be understood. People who need legal services but cannot afford it must be provided assistance. In this regard, we also need to be careful with the new style of everyone coming to the courts. Because you see, we spent 4 years in law school, now 5, to study the law. And you go through a rigorous process of training you to practice the law. So we should not also allow people who are untrained to purport to practice the law. That's very dangerous, because then you're going to have untrained doctors also practicing medicine. Then you have untrained pharmacists practicing pharmacy. You start finding people who have no skills in guns playing around with them. Let everyone do what they're trained to do. So, President Law Society, the bench, please, untrained practitioners should be left out. Should be left out. They should find lawyers who should be the ones practicing before court. There is no right in the Constitution for you to defend yourself in the court in civil matters. No, it is not there. We've argued about it over and over. It is not there. I've read the Constitution inside out. It's not there. And it should be disabused, because that misconduct reflects badly on us as practitioners, because the other person in the village doesn't know the difference between an untrained lawyer and a trained lawyer. As long as you're appearing before the court, you're all what? You're all lawyers. Ensuring justice and fairness also involves a representation for those who may be politically unpopular and may not be very appealing clients. Representing those clients can be very difficult, especially when many non-lawyers see only the unpopular position. The individual takes and have trouble understanding the need to represent even unpopular views. It's a thing we need to start training ourselves as practitioners. Yours is to look at the law. Look at the law. Finally, and maybe most importantly, being a good steward of justice means that we have to go back to a basic truth. The law is a noble calling. To practice law is a privilege. It's a privilege. It's not a right. You don't have the right to practice law. Do not forget what our calling is about. It is not about winning or telling a client what he wants to hear. It is about making sure justice is done. It is about finding real solutions to real problems with the satisfaction that justice has also been served today and into the future. On one of the forums, when we are saying, they say, justice be served even if the heavens fall. Let justice be served. So a group on which I am, one of our lawyer groups, every time they are calling me out, Attorney General, let justice be done even if the heavens fall. But every so often you issue an opinion and someone comes and says, but you guys, why aren't you happy about this opinion? No, that one, no, let justice be served even if the heavens fall. So for us, ours should be a very simple task. Read the law, interpret it, and interpret it truthfully. We enter this noble profession because we want to help people and solve problems. The justice system is our tool to do that. Members of the bar, the justice system is our tool to do that. Can you imagine if you went to if you were a farmer and you have a hoe or a tractor, and you go and decide that since the rainy season has come, you dismantle your tractor. How are you going to plant? How are you going to plow? So members of the bar, please let's not destroy the justice system. Because if we destroy it, we will have no tool. However, we cannot expect justice to prevail if we take it for granted. We have a choice. We have a responsibility. We can be stewards of justice who fight to ensure access, who are professional and civil at all times, who look for real solutions which will stand the test of time, and who will embrace changes to the practice of the law and will enhance justice. We must be ready to be guided. We must be ready to learn. There is something new every day. I've not been shy about recalling my opinion when I've been found to be wrong. I said, no, that one, you're wrong. I'm sorry, I noted, I have been advised that this section, I misinterpreted it. I'm recalling that opinion. Give me some time to study it. I'll come back to you. Because there is no point. You must be ready to learn. There are some laws that I didn't even know existed until I was in Attorney General's chambers. Some laws in this country, there are so many. So if you're a practitioner, you must be ready to learn. There's something new to learn from everyone you meet every day. Let us use this forum to dialogue with the view to ensuring that people get real justice. And dialogue means listening to each other and listening, not hearing, but listening to each other. I once again welcome you all to this Bar-Bench Forum and wish you fruitful deliberations for God and my country. Let me also take this opportunity to invite the Honourable Minister of Justice, Honourable Mururi Mukasa, to make his remarks.
The Honourable Attorney General, my lords, the judges, the principal judge, and your worships, the magistrates and registrars of courts of Uganda, the president of the executive of the Uganda Law Society, the director, public prosecutions, director, CID, members of the bar, ladies and gentlemen. I came here a little bit late because I had to pass through Parliament this afternoon. There was some issue that we had to deal with. It gives me great honor and pleasure to address you and welcome you to this year's Bar-Bench Forum. And I'd like to thank you for the invitation to discuss and find solutions to some of the practices and omissions or commissions that have an effect on the effective dispensation of justice. I thank you really for the great service that the judicial arm of government is doing in order to align ourselves to the provisions of Article 126 of the Constitution. This is an important forum, really, and it gives an opportunity to the bench and the bar to discuss the matters that are pertinent to the administration of justice in the country. And it's through fora like this that cordial and constructive working relationships between the bar and bench are nurtured for the advancement of the administration of justice. I'm informed it's an annual event. How I wish it could be a quarterly event so that really the issues that come up are discussed in time and solutions found for the overall betterment of the administration of justice. Justice and its administration is hinged on Article 126 of the Constitution that provides that judicial power is derived from the people and shall be exercised by the courts in the name of the people and in conformity with the law. The most important principle in the administration of justice is equality before the law, irrespective of social or economic status. The concept of administration of justice is based on the following, really, which were very ably enumerated by my lord, the principal judge. Integrity, that's very important, the members of the bar and the bench. Accountability. Innovation in the administration of justice processes. Improved terms and conditions of service for the judiciary staff. Public and stakeholder engagement, which an occasion like this one really provides. With regard to members of the bar and their role in promoting the administration of justice, there is need for increased accessibility to legal representation. The promotion of knowledge and exchange through continuing legal education and peer support. Recently, the judiciary introduced the Electronic Court Case Management Information System. Very good innovation, because it allows for electronic filing cases and documents with a view to facilitate the efficient and reliable collection, the organization and distribution and retrieval of significant amounts of case-specific data, as well as processing payment of relevant court fees and fines. So I wish to applaud the judiciary for this aspect or piece of innovation, and hope the same will be replicated in all the courts across the country. And this will go a long way in easing judicial processes, therefore promoting effective administration of justice. As government, we are committed towards ensuring a system that works for the citizens and pledge to support programs geared towards that. This one, simple innovation, but very effective, and we could say really revolutionary. I believe that if we can simplify the legal procedures and strengthen the current legal aid system for the indigent, it would encourage this section of Ugandans to access the judicial system. Innovation would also have a positive impact in reducing case backlog. There's still a daunting task ahead of you to ensure that the backlog is significantly reduced, although we're given hope by my Lord, the Principal Judge, that this is something which is going to be history as we go along. But we've seen over the past years the effort that is being made to reduce the backlog through the handling of cases in sessions. We have the Attorney General Chambers, which is bombarded with numerous hearing and scheduling notices, for constitutional petitions. We have had several sessions for civil appeals, criminal appeals, and currently, really, the election appeals. So innovation of this nature will certainly go a long way in clearing the air and easing the backlog and the problems. Would like to advise that prior notice be given to stakeholders before the sessions begin. In that kind of meeting, it would be required to see the state of preparedness of the parties and their counsel, so as to limit adjournments and case backlog. We'd also like to see handling of cases on a first in, first out basis, unless other circumstances or exigencies arise. This, in my view, would buttress the impartiality of the court. I'd like to propose that the court makes or runs bulletins for the judgments so far rendered. This, I think, will ease research and also decongest courtroom, as the advocates will be able to advise their clients on the strength of their cases. These bulletins, I think, will go a long way in easing research of the court assistants and the judicial officers, and will ensure that the precedent is followed. In the recent past, we have seen the assessment of judges appearing on papers, in the papers. Well, it's good. It has some good aspects of it. And this is a very good innovation, which I think will increase the public understanding of our systems. And on the other hand, encourage judges who are not doing well to do better. But also, I think, go a long way in increasing the confidence of the public into the judges and into the system itself. Enough really cannot be said about the amount of cases going through our judicial system. The increase in the workload of the court and the need to clear case backlog calls for interventions to speed up disposal of cases in a just and fair manner. To achieve this, there's need to improve the remuneration of the judicial staff. The passing of the Administration of the Judiciary Act 2020 has not only put into operation the provisions of the Constitution, but I think will ensure that the judiciary can independently streamline its processes, including the welfare of its staff. And this will go a long way in improving the administration of justice through motivation, through proper provision in terms of facilities and facilitation. So I hope this will be replicated in all the sectors which are concerned with access to justice, including, but not limited to, the police, the Directorate of the Public Prosecutions, the Attorney General's Chambers, and the Uganda Prison Service. Better funding of these sectors will improve the efficiency and effectiveness of the administration of the judiciary. There is therefore need for this chain in the application of justice to work closely together. It will not pay for the judges to be well remunerated, and then the people who carry out the investigations to be grassing, and they're not well remunerated. Or those who go out and stand in and prosecute those people to be poorly remunerated. If only one sector is well handled at the expense of the others, or even the prison service, then access to justice will remain a mirage. And the whole idea will defeat itself. One of the major problems that has beset our judicial system is the lack of integrity, or the perceived lack of integrity. Therefore, among some members of the bar and the bench, and even the public, besides hampering public confidence in the institutions and undermining stability in the fragile context, corruption and lack of integrity in the judiciary, I think in the end amounts to a human rights violation. Judiciaries can correct this perception by embracing initiatives that promote transparency, that promote integrity, community engagement, and even open justice. The idea of demystifying certain things comes in. And the concept of demystification has been with us since 1986. At least now, the gun has been demystified. Not so? A uniformed person can not come in this hall like this and with a gun and wave it around and then everybody will be quaking. No, they'll be quaking as a tactic, not because they are really to the core very much worried, because the gun has been demystified. I think one or two people in the hall will, if that fellow is not steady, will go and disarm that fellow. So there is need to demystify even other aspects, including the judiciary, so that people know exactly what is in store for them, and then they can participate and cooperate with confidence in the system altogether. Judiciaries, even elsewhere, actually join forces and support each other in developing mechanisms that help deliver justice for all. This can be made possible through initiatives for fostering transparency and promoting integrity and increasing the public trust. The sanctity of courts should be protected at all times. The Attorney General said it. From attacks from the public, but also from members of the bar. It is quite confusing and a little bit frustrating when you hear a lawyer or an advocate, attacking a judge or declaring his or her lack of confidence in the entire system altogether. Then if that is the case, what are you doing in that arrangement? be honest yourself and resign. Not so? Get out. Yes, just be honest and say, look, I can't serve this system. It is rotten to the core. I cannot go along with it. Resign. But don't just go there and start attacking and, carrying out or commenting nastily and, giving caustic remarks, maybe if not in court, but in the social media. There is a cultural approach. There's a word here in most of our languages that refers to revolutionary shame. Ensoni, or ensoni. Where has that one gone? How can you say such unkind words or untoward words, uncalled for, before, about a judge, about a magistrate? And you have the courage to write it and to own that. Honestly, is there no way you can make such comments not in the public purview? The Baganda have a saying that nanyini chigwa yachiwebula, that the owner, or those who are very close to the establishment, they are the ones who bring shame to it. So let this not happen to our justice system. Once the justice system loses the public trust, then I don't know what may happen later. So it has become common practice for lawyers to do that kind of thing. Every time they are not satisfied with the decision of the judge, they attack the person of the judge. This is wrong. This is wrong. Yet they know their avenues for redressing the perceived or whatever weakness they have seen. If you're not happy, you go to court, not so? Yes, go back to court and say, look, this one, no, I don't think it's okay. But don't go to the press, don't call a press conference and begin saying all kinds of things. Now, if the judge also goes to the press and eventually says, oh, we know you. The other time we saved you, you are receiving a bribe from so-and-so, or we have really, just helped you for some time, but otherwise you're a nuisance and a disgrace. So what will happen? So it's not good. You can't therefore go to Twitter or Facebook, this kind of thing. And I would like to say, really, those Twitters and Facebooks should be avenues for improving, for positive criticism, if there is any criticism to be made, for proposals or ideas which help to make the system better, but not to degrade the system and wear it down. And in a situation where we have so many challenges, I think it is not even patriotic for you to do that kind of thing. We are building institutions in this country, and I think this is the time that we, as citizens of this country, are handling these systems ourselves. And we fail to realize that this has just started. We tend to compare ourselves with the longer established systems elsewhere. And we forget that we are Ugandans here. You see? But when it comes to something slight that has gone wrong, then you immediately your Ugandanness ceases, you now become an American. The Bill of Rights, this or that. Oh, but my friend, those people have been around, since, when was the other one? The habeas corpus something proclaimed? The Magna Carta. Some time back in the 14th or 13th century. When did we have a Magna Carta here proclaimed? Actually, for me, I think it was in the 1995 Constitution. Oh, there was something around independence, 62, just 50 or 60 years ago. Now, somebody who a document that has been around for over 500 years, and this one where you have just embraced it anyway through a foreign language, you know, about 50 years ago, and then you want, no. So let's be considerate and help to build the institutions, to build the confidence that people should have in us. And in that way, we are going to be patriotic and help. Now, if the judiciary is derided, the military is derided, then the educational system, then the health system, then agriculture is derided, then where are we? Next, even your person is going to be derided. Yes. Even you as a household head, the people under you, your wife, your children and grandchildren who deride you, then where are we going? So this kind of thing should not be allowed. Now, Article 127 of the Constitution of the Republic provides for participation of the people in the administration of justice. Now, I would like to encourage the judiciary really, and the bar and the bench, to ensure that such fora are conducted, you know, on the rolling basis with the aim of training even the public on the judicial system. This one is now exclusive for the practitioners. People have gone to school and know, and you know, they know the ins and outs of it, the intricacies. That's very good. But also now, there should be another one, really, for the public. Should be another one. It may be very expensive, but I think it is not possible to have. It's not impossible to have. You know, cutting here and here, maybe holding this forum instead of holding it here. It's a very, very exclusive place. We could have it under a tree and save a little bit, and then we go, you know, in the idea of a baraza. A baraza, a meeting, public meeting, not in a very expensive convention hall like this one, but somewhere, in a school somewhere, so that even the public knows. And it saves a lot of things if the public knows. And the myths about the judicial system are dispelled. It will add to the confidence and really to the support and the faith that the public will have in the judicial system. You know, knowledge is key. When we know, then we know what we are doing. If we don't know, we are beset by a number of things, including unfounded fears. And we become prone to faulty arguments, you know, and all kinds of things. And of course, this is the general line of transparency, and in the end it will create trust in the system and ultimately improve access to justice. So please, members of the Law Society, intensify these current efforts you are carrying out to raise and uphold the professional standards, the integrity among the members through continuing education, training, mentoring, discipline, and peer review. Those judges who have retired, they have retired, but they are not tired. Yes, and they have really rendered illustrious service. So let's exploit them to the last day. Yes, they have a wealth of information, knowledge. They can be very good mentors. They can be very good peers. Let's borrow a leaf from the traditional society. When a grandmother is there, of course, she has had her time, done everything. The grandmother is usually given access to interact with the grandchildren. And the purpose is really to help these small children imbibe the cultural traits and values of the community through talk, through, you know. So these grandmothers act as peers and mentors. So why don't we turn our retired judges into that category? You know, judges who are still in practice, consult them from time to time. Those who are at school also interact with them, and so on. So that we preserve the best. And these ones act as role models. It is never too late to get a role model. Even at 70, you can have a role model. Yes, when you know, oh, this one, yeah. Therefore, at least the best practices, the best values will receive continuity, and that will be for the good of the sector. I wish to conclude by thanking the President of the Law Society for inviting me to this function. I also would like to thank all of you who have taken off your spare time to come here today. In the direction of achieving better cooperation between the members of the bench and the bar, and with a view towards improving the administration of justice in the country. I thank all of you for turning up to this forum and wish you good deliberations, and hope that the exchange you are going to have will not only just be commonplace, but will be very important and form a stepping stone to a higher and higher standard. Thank you very much. For God, my country.
The Honourable Minister deserves another hand clap. Would like to thank you for your presence here, your words of wisdom, your gracious speech. I think graciousness perhaps comes with age. I look forward to being gracious in my speech. Your gracious speech, which has added so much value to us, and also the discussion for us, or the commendation for us to take it beyond here and go to places of barazas. I think that's such a good idea. And I think the Law Society welcomes that. And it's something that we're going to think about, and also something I hope we can do. There are a number of comments online, but we shall address them. The Honourable Attorney General, you received a number of hand claps in the chat. I'm sure they were just short of a standing ovation, but you received a number of hand claps. People appreciate you. They said great remarks. Please note the language is not mine. Great remarks. They said your presentation was educative, it was direct, informative, and they appreciate it. There were a few comments about the coffee agreement, but my eyesight fails me at this point in time. I will pass them on for you to read directly. The Honourable Principal Judge, there's a comment that someone made, I think quoting you, and it would be remiss of me if I did not just read it out to you. I hope I can find it. I think they say it is, I'll say the person's name. This is Godfrey Musinguzi says, enjoy the little things, for one day you may look back and realize they were the big things. Great steps towards improvement. Despite the little bad grape, sanity is a little felt. Thank you, the Honourable Principal Judge and the US leadership. Thank you so much, the Principal Judge. We also commend you for looking at both sides. And I think every speaker who has been here has looked at both sides. For me, it shows that you are welcome and open to receiving feedback, and the Law Society appreciates you. My Lord, thank you so much. So members of the bar, we are not going to unmute you. I see a number of hands up, but we are not going to unmute because we are running out of time and we want to respect everybody's time in the room. We're going to receive comments. Now the comments that came in before today, I was going to say honorable, I think I'm prophesying to Madam Secretary. She's going to read out the comments that came in earlier. I will take a few online comments. Now, because a number of them have been addressed in the speeches, we're going to just run through them. I'm going to ask the Chief Registrar to just classify them and respond to them broadly. And those that you can't handle, I'm sure my Lord, the principal judge, may handle. The DPP also has a few comments coming in and which she will respond to, and then we can go on. Let me welcome the secretary who will take us through the comments. Please welcome the secretary.
Good afternoon. Allow me to associate myself with the protocol earlier observed in the interest of time. As stated by Madam VP, we sent out a feedback form to our membership. My role here is really to give this feedback or the responses, but coming after very competent and powerful speakers who handled both sides. In the interest of time, I will not repeat, and I will just highlight the ones that were not touched. And Diana here will help me pick the ones online, because I didn't have access prior. The Honourable Attorney General made a comment which stuck in me. I knew it briefly, but that this is a marriage. And I was just wondering which stage of the marriage we are. It is reflecting. We've not yet gone to the counselor. We are going to sit in the room and talk about our problems. And hopefully we shall have a time for way forward. How do we move? Because we may state the problem over and over. They're the same, by the way, that have been highlighted by my Lord, the principal judge, and the Honourable Attorney General. So comment number one, which members of the bar would like to be addressed, is on ICMIS. Your Worship, the Chief Registrar, members are saying that they know that change is inevitable. And they also know that it can be painful, but things are becoming quite difficult with ICMIS. Would like you to address us. Members feel that the system was rushed. Filing online takes weeks before action officers can respond. This has led clients to discredit our services. Someone suggested that is it possible to suspend the system until staff of the judiciary and members of the bar are trained. We know that could be a tall order. We have to move forward. But there's also a suggestion that could it have been done in a phased manner. Would like to hear on how we can really bring back the efficiency. We know the system is supposed to improve efficiency, but it's causing problems. The other issues, really, I don't want to repeat the judicial conduct. My Lord, the principal judge, talked about absenteeism broadly. It's cross-cutting. There are about 100 comments on absenteeism, on fixing matters at the same time, and you have to wait up to the afternoon. Personally, I had to wait for one case up to 4 p.m. from 9. It's very, very painful. So I would like to have a way forward. How do we move forward? We understand that there are issues also of backlog, but we just need to make the system more efficient. So again, absenteeism, there are some judicial officers who are always sick, and when they return, they don't give fresh dates. There are also cases of disrespect of lawyers, some judicial officers who have been, I think, verbally abusive of lawyers in court, arrogance and disrespect. But maybe it's also touches the other side of preparedness by the lawyers. It's something that we need to address between the bar and the bench, because someone was very passionate that she was shouted at by the judicial officer and asked to leave court. The other comments, There's a concern about streamlining court fees payment on land matters. That previously there was an initial figure of 25,000 for every land matter, but now the value must be attached to every land, and fees are assessed. There are issues, I mean, like I said, I don't want to repeat the efficiencies in the system, but one that has also come out is the system of precedent seems to be disappearing to an extent that even when a practitioner presents a case, a precedent, there's a lot of uncertainty. Yeah. Are lower courts bound by higher court decisions anymore? I think that's of key concern. Then, lastly, before I hand over to Diana, because like I said, there are like 100 cases on communication, respect. It's the same thing. But industrial courts, the lawyers are really requesting for a replacement judge. It has been 2 months since the Honourable Justice Rohinda retired, and now that has led to case backlog and adjourning of cases. So there's an appeal that the replacement be done. Yeah, that's what I can say in the interest of time. Like I said, I hope we can share, Your Worship, the Chief Registrar. We can compile this feedback in thematic areas, and maybe we can find a way of now forging the way forward. But I'll hand over to Dana to give the online feedback.
Thank you, Madam Secretary. I note that there are a number of comments coming in from a section of our membership, and I know it's a Bar-Bench forum. We're going to try as much as possible to go through these comments. Let me just ask that we will share them as Rita has said, but whatever you can respond to now, we welcome a response. So someone spoke about unifying the systems between ULS and Law Council and court to ensure that they get practicing certificates on time, and how can the courts help us? There was another comment on renewal, that should we renew pieces every year or we should renew them every other year? The other comment is we should do away with criminal and civil sessions to remove backlog. There were quite a number of comments on backlog. The other person is asking, why do we have transcriptions in trials when there's delay in obtaining proceedings from court, which delays appeal processes? The other one is, are there plans to revise the pecuniary jurisdiction of magistrates' courts? Then this one was quite interesting. Should lawyers facilitate magistrates for locus visits? And that one came more than once. Then another person asked, can you create different courts for land, environment court, civil court, employment, labor relations, and insolvency division, and empower those different divisions to function? Another person asked that you provide cars for judicial officers so that they can make it to court on time. The other comments about ICMIS, they're asking if ICMIS can be rolled out up country, and there should be monthly trainings for 12 months until advocates are abreast with the system. They're also asking that you use our emails as lawyers' emails so that you can communicate if you are not coming to court. The other comment is about corruption. Someone says it's still a big problem, and how can we find solutions to address it? Someone asked whether sessions, criminal sessions in high court can be had concurrently with other sessions. I'm sure we recently launched a backlog. We recently launched one of the things from court, doing away with sessions, particularly in Kampala. Someone asked that the principal judge issue a circular about judicial officers communicating to lawyers so that they can come to court on time. There was a specific request to the commercial court. Someone says they filed pleadings with ICMIS and it has been a month since they had a response that summary suits are not disposed as fast as expected. They are also asking if you can amend the law to allow constitutional matters to be heard by High Court. And then there was a comment, particularly from Muvende Court. I thought that it would be interesting to read it out because the person was quite passionate about it. They wrote it both in the chat and the Q&A session so that we would capture it. So let me read it out. I was in Muvende High Court this morning. The resident judge is out of station. The deputy registrar is out of station. No magistrate is present to adjourn the cases. No prior notice to court users. It is really sad. In such a case, how does one get costs of the day? You can see our interests. Okay. Despite the recent recruitment of magistrates, some areas have not been operational, and how can we work around that? Someone's asking, I think this one's to the President, what is the progress on amending the Advocates Act? Then backlog is still a problem, and how can we balance sessions and with ongoing trials? Someone says with the recent recruit of magistrates, we don't have resident state attorneys, and so how can, they are much fewer than the magistrates, so what should they do? Judgments have been delayed in certain courts, particularly Ginger High Court, because of the previous judge left with files, and they want to know when they will get their judgments. There is a comment for the DPP, which I will also read. I want to know from the DPP which law the state attorneys use when they request to verify documents before bail is granted. This practice of prosecution has been used as a weapon to frustrate justice and as a means of solicitation for bribes as the accused is on remand. Someone asked that we break down the bar and bench sessions into particular clusters so that we are dealing with different divisions as we have a bar and bench forum. For the CID director, someone talked about respecting of court orders. Why is the police not respecting court orders? And then there's a wide outcry about detention beyond the 48-hour rule, and what can we do about it, or what is your office doing about it? The DPP, again, there are delays in returning files once complainants have been produced, and so the lawyers are asking how that can be remedied. For prisons, with the lifting of the lockdown, some suspects have not been produced before court to date. What are the prisons doing? Those are the questions that we have so far. Members of the bar, I note that there are so many questions, both in the chat section as well as the Q&A section. We may not be able to address them, but we are going to send them to the judiciary and the different arms here so that we can have another platform when we can easily address them. Now we're coming to the tail end of our program, and before we ask the different people to respond, and I think I'm going to ask the past president, I think led by Senior Counsel Sebugenyi. There is a slot for you to give responses on behalf of stakeholders. Am I ambushing you? I am ambushing you. I apologize. It is not my problem. But as senior counsel, the very fact that you earned the title senior counsel, you should always be ready when it comes to Law Society events. But I would ask you, I don't know if you have any concerns about the bar and the bench that you would like to present at this moment. And if not, okay. Everything was addressed. Thank you. Thank you, Senior Counsel. I'm going to ask my Lord, the DPP, if you were ready to respond. And after the DPP, we will have the police and then the prisons respond before we have the judicial respond. My Lord, you are welcome to respond. Please clap for her. We gave you lunch.
Good evening, everyone. Okay, if there is a law for verifying documents, I can say there is no law. But I think it is just, what can I say? We are officers of court. If you really think that we are, because most of the time, when I was in the criminal division, we put a session for only people who were given bail. And I didn't even get one of them. 40 cases, I didn't get one of them. None of them came, and everything just died like that. So, and we have had actually times when we verify these documents, and we find, the lawyers know it, that we have professional sureties. So if you really want us to not to waste time, you could give us these documents before. But you find that these documents are given to the state attorney as the lawyer is making their submission in court. They are thrusting you with papers, one paper after another, one paper after another. So I think it is just in the interest of justice. Because as a prosecutor, I am there for the victim of crime. So I should really do my work as well. Just like you had all the time to prepare yourself, get all this documentation, why not send to us, even by email, send to us and we verify them. So there is no law, but it is just fairness and justice, because we are all in the business of justice. So we should be just to the accused person, to the victim of crime, and it is our duty to court. Then delay with files. Delay with files comes with there are so many angles to it. I think it all goes back to that we do not, the Attorney General mentioned it, the Honourable Minister mentioned it. The work we do, we don't really explain it to the public. So even people don't know how even these files move. Because for me, to call for a file, most of the time lawyers come and make complaints. And I am really at pains to call a file because I know it will take about 3 weeks for that file to arrive to the DPP's office. Because I'll write the letter goes to the registry, it is dispatched from registry to the police receive the letter, start looking in their stores for the files. If it is not on the desk of the IO, then they take it to they forward it to the OCCID, to the director CID. If the director CID is not on his desk, maybe he's in the field, has to wait for that, then the file is forwarded to the DPP's office. When it arrives, it goes to registry. When it goes to registry, this file has to be scanned because we have what we call PROCAMIS, Prosecution Case Management Information System, where we're trying to get all the files to become e-files. So these files are scanned one paper, scanning. And we have one heavy-duty scanner to scan all these files. So if it is a file of anti-corruption, you'll find there maybe there are even 3 box files, maybe 6,000 papers you are scanning. After it is scanned, then it is entered in the system, then it is now brought to my desk. It takes so much time, and in the process of, I notice most of the time even these complaints are sent strategically to delay, because some files are coming in court that same day, and it's a complaint, and I'm not aware that it's coming in court, and I call the file, and the file is sent. So everything is derailed. So when they go there, they say there's no police file. So the delay in files, of course, others it is because of just corruption. People just hoard files. They keep files, and they don't, either from CID, you call from CID, they're not bringing the files. 1 week, 2 weeks, 3 weeks, 1 month, they're not bringing. Or it comes to DPP's office, and you don't send back, because it is a police file, you're not supposed to keep it. You're supposed to just minute on it, read it, minute on it, and send it back. But you find some state attorneys keep the files for 1 month, 2 months, So some of these, it has so many dimensions, delay with files. But we're trying to put in place systems where it pops every time the file has stayed with you for 10 days, it pops and says you have been with this file for 10 days, for 15 days, for 30 days. So then you have to actually explain why you have been keeping the file. You have to give an account of the time you spend with the file, unless if the file is a big file. I would also like to comment on, I know it was forwarded, it was a question for my brother, Director CID, the 48-hour rule. The 48-hour rule was made, I think it came in the 1995 Constitution, if I'm not mistaken. The 1995 Constitution was written by people who had gone through a lot. They had gone through a lot. They had been in custody for months, years, without appearing in court. They were, during the Means regime. So by the time they are writing this Constitution, they're actually trying to see themselves in it. So the 48-hour rule, when we speak now of offenses that we are terrorism, and let's even say murder, because of the use of technology, the way offenses now are committed is you cannot even think about it. 10 years ago, it was slow, but now it has become like in a click of a button, an offense is committed. People use technology. It has become so sophisticated. The Attorney General was talking about cases of corruption. So syndicated, you can't, it is like an onion. You can't unravel it. So the 48-hour rule, I personally, I am just thinking that it is not, you cannot make it a rule for all the offenses. I think we should be able to go back to our law and maybe make it that if the police and the office of the DPP need more time, we can actually go to court and ask court for an extension with reasons that can we have more days to, because you cannot investigate a terrorism case in 48 hours and be able to bring the case. Otherwise, we are going to have so many cases in court, and at the end of the day, I am withdrawing cases, and then they say the office of the DPP takes cases to court prematurely. It is because you are there on, and then the 48-hour rule is at the backdrop. It is not thinking about the fact that actually the 48-hour rule thinks it is an ideal situation. The police are there, many. A police officer has only 5 files per police officer. The prosecutors are there. We have the 853 in place. The magistrates are there. You see, So, but you find that the 48-hour rule cannot work in a place where there is only one prosecutor who is appearing in court, who is perusing files, who is listening to members of the public. The 48-hour rule cannot work. You see, So for that, I'm just thinking that it is something that we should start, it's a conversation we should start thinking. We don't do away with it completely, but we can make a provision that we can actually go to court and ask for more time in particular cases with reasons. And then the courts can weigh and either extend for us the 48 hours or not. I think those were what I was supposed to. Maybe I should also mention about private prosecutions very briefly. There's always a backlash. I receive so many messages. Why do you have to take over and then withdraw? I manage prosecutions in this country. I control them. If I manage and control them, what am I supposed to do? Just to leave people doing private prosecutions and I see that they're doing the wrong thing? I think the Constitution, the framers were not, they were alive to that fact that there's supposed to be some kind of orderliness. So when we take over private prosecutions, we actually ask police to open up a case and investigate. And we have investigated them, and most of them we have actually withdrawn because we find there's just no case. And we write to the person who complained and say, actually, I think I've written to my Brizina 3 letters, explaining to him why we have withdrawn the case from court. Thank you so much. Sorry? No, I think that's a conversation that we're having. It is a nightmare for the office of the DPP, but I think it's being handled. That since the judiciary is recruiting, there is just no way that DPP cannot recruit as well, and Attorney General's chambers, because we are together in court. it is. I think for us it is a blessing in disguise. We are actually happy that they're expanding every day. When I see the judiciary saying, Judicial Service Commission saying we are asking for people to apply, we are actually celebrating, because we know that it's just a matter of time before we also start asking people to apply. Thank you so much.
Thank you, my lord. Okay, let me invite, because we're running short of time, let me invite the CID director to please come and respond. Please clap for him as he comes.
Our acting Minister of Justice, my brother, the Attorney General, the Principal Judge, and all protocol observed. In the interest of time, you will allow me just to respond to our questions. But before that, I want to take this opportunity on behalf of the Uganda Police to thank you for inviting us, Madam President. We were very honored. My boss was not able to be here. We have quite a lot up and down, but I'm glad that I finally made it on time. Although I was trying to understand the bar and the bench, I don't know, maybe we should make it a tripartite. The Honourable Minister will guide me. You know, some of us, it looks like it was duo, the bar and the bench. But then the bar and the bench cannot work if the police, if we other people who also bring these people investigate are not there. So maybe in future, since the Honourable has advised that it becomes more regular, we could change the name. This name is not balanced. I actually thought I was out of place. So that one is for food of thought. I was very happy the Attorney General asked very good questions. Why do people go to court? What is our calling? I've been this morning talking to a group of our field officers, and we are really asking the same question. You know how to do the work. You can investigate, you can take statements, but why do you do that work? And I think that's a fundamental question I want to add on the Attorney General's questions. Why are we waking up to do the work we are doing? I think we have a cause. We have a cause which we must define. Now, they have asked us questions here on respecting court orders. Oh, the Uganda Police, we really respect court orders. My only problem is when I was here, I heard the principal judge saying that some of our land friends are found of forging court documents. It's not me. So because of that worry, when we get these court orders, Uganda Police also wants to be sure that some elements have not actually forged them. And we have many cases where there is clear forgery. So partly the delay is to try and verify through our Directorate of Legal, and when that is done, then we would be able to operate within the law. So yes, there could be a delay here and there, but basically is to guard against implementing what perhaps is a forgery. But then the other second one, there has been a practice that for these court decisions or orders, the bench should go down on the ground in many cases, especially the land conflicts, which are numerous. Unfortunately, I want to report to you, my lord, some of your people make these decisions when they even don't know where this land is, how many people are affected. Then people are cutting each other, and then police will have sleepless nights. So one of the challenges we also have there is making court orders without the bench taking an initiative to go and see, you want 1,000 people to be removed from a particular area. To remove them is a problem. People will get pangas, will get everything to defend their small property. So as police, because we are the ones who have to spend sleepless nights, we have to take some kind of time to do due diligence. But other than those two reasons, there's no doubt we are law-abiding and we shall follow the law. Detention beyond 48 hours, my sister, my Lord has explained the history. I don't want to be misunderstood. She explained this very well. But I want just to add, as police, we are also taking some reforms. When the president of the Law Society and her team visited us, we shared. I have had you list a lot of problems. Actually, I thought it is only in police. When I listened, I wrote, my notebook is full. Corruption. There are things I didn't expect to find in the bar and the bench. So I was very amazed, Honourable Minister, that at first maybe I can go and sleep. I thought these problems are only in these people who are not learned. But the problems are here. So this is the same society we are dealing with, which is producing lawyers, producing policemen, producing businessmen. So we must together ask ourselves, how can we work together? This is why we are very excited to be part of this partnership. There are institutional reforms, the IGP, we have a huge discussion. Like I'll give you 1 or 2 examples why maybe we are delaying to produce people before court. The Uganda police is in the process of setting up a case management system, an electronic case management system. We actually have been blessed to chair the management committee. In the 2 months I've been there. We are trying to say, how can we computerize some of these things? Much of it is still manual. So for you to process that entire chain and reach the DPP, the volume of cases, the volume of work, vis-a-vis the number of personnel, the resources at their disposal, this is work in progress. But we are moving forward. Although when the Honourable, I think Minister, no, not the Honourable, I think I didn't get this well, but there was somebody saying the court system which we wanted to benchmark, the responses from there are many complaints and people are requesting you to first suspend it, the chief registrar. So maybe even where we wanted to come and benchmark, you may not be the best. So the other day I went to my sister, the DPP. She also has something, but she's also not sure about whether it's 100% operation. So, but this is the same progress we are trying. And if we succeed, and I know my elder Attorney General will help us, if Uganda Police can do that, especially in Kibuli at the CID headquarters, then the speed at which we are able to investigate files and produce them should be faster. But related to that, my second priority there, since the president sent me there, we are trying to centralize a database. You'll be shocked, but not shocking because you are learned friends. We now have the passports, huge database. We have a huge database of NIRA in Kololo. You have heard we are now planning to register the cars and everything. URA has a database of motor vehicles and so on. All these and others, they don't speak to each other. I don't know whether you see some of the strategic problems we have to address. So I've been asking myself, so when I have a suspect, sorry, I was going to say criminal, but I remembered somebody has to be. So when we get a suspect, then I have to write to NIRA that there is a problem. I take 3 weeks to get a response about his details. Then I write to URA to get the number plate of a car. Then I write, I don't know whether you see those procedural problems. Then I have one there, which is our CCTV. Now, what we are saying strategically, government must streamline and centralize access to this database so that now, before I come to arrest somebody, if we have good ground to suspect someone, we shall first run that piece of information, put together a profile about somebody, put together the evidence we could have picked here and there. Maybe there was a murder, same flan, and there was a car. We now know the owner, we know, before we even disturb somebody. Then by the time we send a detective to come and knock on your door, we really have almost 80% of the information we need. And then when we reach that level, it becomes very easy to pick somebody, and within 48 hours, you are able to produce him before a court of law. So these are some of the strategic problems I thought I should add on the 48. So we are moving well. Lastly, we are working towards digitizing our records. You have complained about, I think this was the DPP. I mean, every day I get about 20 letters from the lawyers, 20 to 25. Do this, do this, do this. But to retrieve a file which is not digital. And we have records from 1934. It's a huge, huge burden. So as a last strategic intervention, these are the 3 things. And we believe once we are supported and we streamline this as Uganda Police, then we are going to be stronger partners in trying to make sure we can have a quick and expeditious process. Thank you very much.
Thank you, Major Doctor, the new CID boss. Thank you so much. Major Doctor, which one should I drop, the Major or the Doctor? No, you don't, this is not a court. You don't have to come.
Sorry, I should clarify this. I'm now an AIGP of Uganda Police, but in the army, I'm a major. Okay? And the other doctor, those are academic things, they are not important. So for purposes of record, I'm an AIGP here, a director of CID of Uganda Police. Thank you.
Thank you, AIGP, and we shall silence the other titles. Okay, I'm going to ask, not now, but I'm going to ask 2 advocates who are on the platform. I'm going to give you a chance. I'm going to give 2 advocates online an opportunity to say something or to ask a question. This is my only ask. Please be respectful. This is my only ask. I can see the temperature has heightened in the chat room. I ask that we be respectful. This is a bar-bench forum and we understand that. So I'll give only 2 advocates an opportunity to ask questions. So if you want to ask a question, please either put up your hand or write something in the chat or the Q&A and I will pick you. I know that we have really run our time. I was supposed to invite you to tea a couple of minutes ago. We're going to have a working tea. So I'm going to ask that you stand up, and if you can, and they will usher you to the tea that's right behind you. You can get something to eat. I promise you, it is safe. Then I am going to invite the representative of prisons to just give us 2 minutes, at least 2 minutes of response to what has been asked. And then we'll have the judiciary respond to the questions that were placed in the chat. After the prisons, we'll take 2 questions from advocates, and then we'll have the judiciary respond. You are very welcome.
Thank you very much. I am Chivumbi Jacob, Assistant Commissioner of Prisons, in charge of Prisoners Administration. From prisons, I came with the Assistant Commissioner of Prison, Damali Yonat Kunda, the legal officer of prisons. I thank you for inviting us. I have benefited a lot in what my senior said was a dual activity, but I thank God that we are included. Now, regarding the question we are asked concerning why we are not producing prisoners to court after the lockdown, I think the answer is we are producing prisoners to court. What is happening is that we are having a few disturbances because of the effects of the lockdown. You see, in our struggle to offer safe custody to our prisoners, we moved the prisoners far and wide during the lockdown. The new admissions were taken to specific places we call isolation centers. And thereafter, we would take them to safer places or their magistral areas. What happened was that some of the prisons in their magistral areas, if we talk of like Kauga in Mukono, were isolation centers themselves. So such prisoners would take them to any safe and secure prison elsewhere in Uganda, so that we fight COVID-19. Now, after lifting the lockdown, we have moved those prisoners back to their magistral areas or to the prisons near their courts. In cases where a few of them have not moved there, when we receive the production warrants, we make sure we produce those prisoners to court. We take them back. Our only request is that those production warrants, if they are made in time and we get them, we produce prisoners to court, because that is our major contribution, because it is one of our core values, ensuring justice for prisoners. I think that one answers what we are asked, but allow me also to present a few of the challenges we face. One of them is over time we receive contradictory court orders and sentences, conflicting sentences for our prisoners, especially when the judicial officers engage into the mathematics of prisons, of adding the days and the months and the years. Things don't work out. So we request that we get clear sentences that we can administer, so that we serve justice like the other stakeholders. Also, I think my lord, the principal judge knows, and the chief registrar, we are grappling with a number of convicts who do not have commitment warrants. We only have the notes we wrote and endorsed, but the official commitment warrant is not there. And what worries us is that some of the judicial officers become hostile. When we go following up those documents, they are not ready to sign. So we pray that, as we are emphasizing mutual respect and that we respect each other, and give those official documents so that we make work very easy for all of us. Also, we have observed that, like the rest of the officers have observed, the absenteeism or the irregularity of the magistrates or judicial officers is affecting is affecting our clients, and they are complaining. It raises a lot of tension in prisons when the court operates like once or twice a week, and it is the routine. So since we have been promised that these are going to be worked on, I pray that we shall be in a better, comfortable place. I also add my voice to those who have observed the issue of corruption, but for the councils or the president, our concern is that there are a number, not very many, but a number of quaker lawyers that come to the prisons only to hoodwink our prisoners. Now, like the Attorney General said, when we are in prison there, prisoners think we know, and I think we know, and they say, Afande, can you get me a lawyer? We distance ourselves because we don't want to be part of their troubles, especially the people who take their money and don't come back. But on the whole, we appreciate the Chelsea stakeholders. You are doing a good service, and we appreciate. We also promise to keep doing our best to serve our nation. Thank you very much.
Thank you. Thank you, Afande Chivumbi. Thank you so much. I know that there is so much to cover, and we have less than 30 minutes to go. I don't know if we have seen a few advocates online who want to speak. I see there's Magellan Kazibwe, there's Brian Tandeka, and someone has dropped off. So can Brian please, if you can unmute Brian, ask Brian to unmute to give his question. Brian, could you give your question? Please unmute, keep it short, and who you are directing your question to. Brian? Brian, can you hear us? Brian Tandeka? Brian, if Brian is not unmuting, let's go to Magellan Kazibwe. Magellan Kazibwe. Magellan Kazibwe, please unmute. You have unmuted. Please.
Yeah, thank you very much. My name is Magellan Kazibwe. I'm an advocate. My concern is that actually you've given a lot of time to the officials to actually say quite a lot. Yet we believe that this bar and bench forum would really give adequate time to the practitioners, the private practitioners, to really engage more by giving them a lot of time to engage with the bench. But we have listened to a lot of presentations, and I'm saying this in good faith. I think we need to improve on that. Thank you very much. But my concerns are, one, the absenteeism of our colleagues, the judges, especially in the upcountry courts. You find that actually quite a lot of times cases are fixed. You are prepared, you are ready to proceed, you've prepared your witnesses. The judge sends a message on the WhatsApp group, I will not be around for 5 days. I will not be around for such a number of days. I'm attending a training, I'm going to do ABCD. Really go to the registrar for adjournments. We are really constrained. We are getting this, it is really getting so much to quite a number of practitioners. We really need that area to be looked at. I don't want to name the judicial officers, but I think it is well taken care of, well taken noted of, that such a concern is so big among the practitioners, especially in the upcountry courts. Secondly, on the issue of the Court of Appeal, we are also concerned. Why shouldn't the interim orders be handled by registrars? Why should they really be handled by a single judge? I think it is actually now adding on the too much work that the Court of Appeal has. And that again brings in the concern that the appeals take so long to be fixed for hearing. 4 years, 3 years, 4 years, we are not getting the dates for conferencing. So we really want these appeals to be fixed expeditiously. So we need to reduce the amount of time a single judge would handle these interim orders. Let them go to the registrars, this is our opinion, and then the justices concentrate on the main appeals. Then lastly, it is on the issue of
Can you make the last one short so that we take other people?
Okay, it is very short. The mentioning, why would you really list 200 cases for mention? You find a judge has listed 200 cases, they're all coming up on one day for mention. And the interest, we really don't know. Sometimes you find that all cases, almost 90% are dismissed. They are dismissed because there are too many on one day and quite a number of clients or litigants are not informed in time. So those are my concerns. Thank you very much.
Thank you so much. I am hoping the rest will keep it as short as possible. So I do hear your concerns. A number of your concerns were addressed, which the Chief Registrar is going to respond to. They were addressed earlier on. So if you have a question that was either mentioned by Madam Secretary or me, please don't feel the need to repeat it. Let me ask Abdallah. Abdallah, your hand is up. If you can unmute, and please keep your question short. Also tell us who you're directing to. Abdallah, are you there? Has he dropped off? Has he dropped off? He has dropped off. Okay. I see Stephen Sozi. Please keep your question short. Stephen Sozi, if you could unmute him so that he can unmute yourself. Stephen Sozi, please unmute yourself.
Hello?
We can hear you. Please, we can hear you.
Okay. My question goes to, actually it's a concern, it goes to the principal judge and maybe President Law Society. My challenge is to do with affidavits of service. I just ask my Lord to kindly maybe prevail over the judges so that many a times matters have been adjourned because of the reason that the affidavit of service does not name the person who received it. And it's a concern. I don't know whether it's a trick by most of us who are in private practice. Lawyers tend to tell their administrators or clerks or secretaries, whoever receives, not to name, to put their names. They just put a stamp and sign. And most judges don't like that. They have adjourned matters on ground that the service is not sufficient because the affidavit of service does not name the person who received. We only name that went to Gallup Advocates and it bears a stamp of that firm and a signature, but does not name the person who actually signed. That's why I'm calling upon the principal judge and State President Law Society to work out a mechanism of how we could pass that as maybe a law which embeds or makes it mandatory for the law firms to their receiving stamp to have a portion for a name of a person receiving. And also for the judges to now cost or make the advocate who has failed to do that pay the cost personally, because that is another delay of justice. Thank you.
Thank you, Stephen. Daniel Biaruhanga. Daniel Biaruhanga. I'm going to do only Daniel Biaruhanga, Jimmy, and Kenneth, and then I'll take one from the room and we'll go on. Daniel? Daniel, can you hear us?
Thank you. Yes, I am. Thank you so much for the program. My concern I'm raising is about...
Daniel, you seem to be having network issues.
Such assistance to we have fighting.
Daniel, you seem to have
Hello?
network issues. What was your question?
My question is on the research assistants allocated to judges. I have issues regarding to them, especially in Mbarara. I'm now waiting for almost 8 months for 2 rulings in that same court, where I'm always told that the research assistants haven't come up with a proposed ruling to the judge. And that seems to be now trying to be another way backlog in the court, judges not making up rulings
Daniel, we've had your question.
have that matter.
Daniel, we've had your question. Thank you very much. Jimmy Luvale and then Kenneth. The rest of you, I'm asking you to type in the chat. Jimmy Luvale, could you unmute and share your question?
Thank you, Madam VP. Mine goes to the principal. My question is, why is it in most cases that magistrates and judges who are transferred take years without delivering rulings? I have some cases. I have a matter in Mukono where a magistrate was actually transferred to Entebbe, and actually she was transferred in 2019. Till today, we have been writing letters, no ruling. Another case, we have another matter at the family division. The registrar was transferred in, I think it's around 2020. It's coming to a year plus. No ruling. Whenever you go, you write letters, they tell you that actually the registrar even wait with the file. So I think the principal judge should help us and prevail over judicial officers who are transfer. Maybe another question. The last one.
That last one is going to take us another while. What is the last one?
Okay, the last one is we have a challenge on judges who are transferred and not actually replaced. Whenever you write letters that the office be reallocated to other judges, they tend to refuse that we should wait for the judge who will be transferred to such a station. So we ask the principal judge actually.
Thank you, Jimmy.
For his indulgence on such matters.
Thank you, Jimmy. Members, I know that our concerns are the same. We can classify them. We have actually passed them on. So you're going to allow them to respond. But because I see a lady, I'm going to ask only this lady. The rest of you, I am so sorry. Your concerns seem to be the same. I wish you'd write them in the chat. Lydia Nanyombi Mukasa, please unmute. Lydia Nanyombi Mukasa, please unmute and ask your question.
Hello. My question is about territorial jurisdiction of Mengo Magistrate Court to handle matters coming from Kampala Division, Kampala Central Division. Most of the times we are faced with preliminary objections opposing the territorial jurisdiction of Mengo to handle those cases. Most advocates are arguing that it should be Buganda Road, yet we all know that Buganda Road strictly handles criminal matters. So we beg for your indulgence, probably the Chief Registrar, to guide us on which is the right court for us to file our cases, especially for Kampala Central civil cases.
Thank you, Lydia.
Thank you.
Kenneth, I had promised and mentioned your name before. So Kenneth, do you want to say something? Kenneth, could you unmute?
Yes, please. Thank you very much. My question, I think, goes to the Assistant Commissioner of Prisons. And I think we have issues with ailing inmates who, one, have not appeared before court for any pleas or bail applications, and then they are not getting sufficient medication. And each time we write to them to issue to us the medical status of these inmates, I don't know whether it's deliberate or neglect. They never issue such medical statuses. So you find that the inmate is taken from one prison to another continuously without getting specialized treatment. So I'm wondering if the commissioner and the assistant commissioner can prevail over the director of health services, at least to grant these inmates specialized medical, especially those that have not been convicted, that have not appeared before any court, and their matters are still pending, actually under investigations, and have been in prison for several years.
Thank you,
Some
Kenneth.
of which are actually even of advanced age.
Thank you, Kenneth. Your question has been noted. Brian, we asked you to speak earlier, but you were not able to unmute. Are you able to unmute now? Brian Tandeka, you are the last person. Brian Tandeka, are you able to unmute now? Brian, are you able to unmute? Okay, Brian, we don't seem to hear anything from you. The Q&A session, the Q&A particular section has a few questions, and then I'll ask the Chief Registrar to come and respond. Okay, someone says, thank you for this session. In terms of communication, I'd like to applaud the judiciary. It has greatly improved. I applaud the judicial officers in the sorority circuit, right from the High Court to the lower courts for time management and consistency at work. My problem is with the High Court of Mbale, where we have to write a letter before a case is given a date. Why should this be the case? Someone has concerns about criminal sessions in High Court. We have plea bargains that get more returns than hearing sessions, but I'm concerned that they are not given priority. And then Amanya says, why do we have circuits instead of station judges, especially in courts of appeal? I'm going to ask the Chief Registrar, I think, to come and respond, and then she will hand over to the Principal Judge. Please welcome her.
Thank you very much, the moderator. I think we all agree that the questions are many. We will certainly respond to some and keep providing responses even in future. For the others, I will begin with the one of ICMIS. When I was preparing the responses, I was reminded of a song. There's that song, if you have ever sung it. It says, I have decided to follow Jesus, no turning back. No turning back. And I said we have embraced ICMIS, no turning back, no turning back. And the reason why we are passionate about ICMIS is because should we go through the turbulence of the challenges we are facing now and the system stabilizes, we will all look back and say it was worth the effort. We all agree that ICMIS is only 1 month old. We went live on 1st of March, and we are just 1 month and a few weeks old. Certainly the system has just started. And like any other system, it starts with challenges. It's like you start learning to drive a car, you scratch it a bit, you knock a few corners. Sometime down the road, you have perfected, and you're a good driver, you drive hundreds of kilometers. This is just what we need to bear in mind, that the system could not start on a perfect note. And we would have never known the imperfections without the system starting. Certainly the theoretical system was perfect, but when it was rolled out and went live, then the realities that you are sharing as challenges today came in. We acknowledge these challenges, and we are very alive to all the challenges. But we have said the marriage of 1 month must continue so that we perfect it. And all of us have a role in making sure that this marriage works. Now, the challenges Madam Angwech was able to raise, the Vice President raised about 4 of them. It was just last week that I received a comprehensive status report about how ICMIS is performing. And allow me to inform you that we have a focal judicial officer who has been assigned to manage ICMIS in the current 7 implementing courts. And that is none other than Her Worship Rosemary Barebe. If the camera could go to the beautiful lady there. That is the face behind ICMIS. And she coordinates the 7 courts to ensure that we pick up the challenges with the aim of improving them. And before I go any further, I need to inform members that when this started, the pilot courts or the phase 1 courts were supposed to be 18, but we decided to start with 7. And this is where we are receiving all this feedback And the initial plan was that 1st March, we have the first 7. Lot 2 was to start on 1st of April, and Lot 3 was to start on 1st of May. But because the system started and it had a couple of issues to deal with, we have delayed or suspended the rollout in the other courts as we first perfect what we have. So what am I calling us upon to do? Let us support the system as we have already supported. Let us endure with it. Let us learn and unlearn and make a perfect system. We were in Ghana with the Honourable Principal Judge, and we found a paperless system. They are happy with it. But it's not that they started where we found them. Certainly they started somewhere. They had challenges, they told us. But now the system has stabilized. Now let me tell you, in addition to what has been said, the 5 other major challenges that ICMIS is having and which we are addressing. One is the issue of the inadequate training and sensitization of the public. What have we done about this? We have continued to sensitize different members of the public. I believe if a couple of advocates were allowed to speak, they will admit that we have sent our teams, even to their law firms, to train them. In essence, we are committed. Cluster yourselves into about 20 advocates, write to the Chief Registrar, you will receive a team to train you hands-on. So I want to encourage us, utilize the kiosks, and I'll be talking a little more about them and the benefits that you find there. Utilize the call center. There is a specific ICMIS call center that is based at the Supreme Court. You have any issue, you have feedback, you have a compliment, you have a suggestion, the toll-free numbers are there, and again, I will share with your president and she can post on your pages. Utilize this and give us feedback so that we can improve. There is a system challenge. Sometimes it is slow, and people have raised concerns. How about timelines? Our technical team is working around the clock over these issues. Inability of advocates and litigants to access their old files. This is another challenge that has come to us. And we are saying we are now still continuing to fully migrate from the old system that is CAS to ICMIS. The process is not yet complete. So we encourage that members continue to go to the kiosks and identify with their old files as they get uploaded from the old to the new system. Surely, I believe, should the clock run round and next year we are here again, we will be saying a different story about ICMIS. The 4th issue has been the issue of delays. Somebody raised it, and that issue is within us. Our own officers have noted they are still learning to utilize this system. They are still learning to interact with this system. Not that trainings were not done. Trainings were really done. But then when the system was a daily thing, it's another issue. You can learn to drive today, but should you drive every day of the week? It's a different experience. This is what we are going through. But we have not sat back. In 2 days, we are meeting all the registrars of the 7 implementing courts, again to further discuss these matters with one aim, how to improve. The other challenge that we all share is change management. The bench and the bar, this is a new thing to all of us. And we all know that the comfort of the old system. We were so comfortable with it, but somehow the time has come for us to move. And I beg all of us, we are doing our work in-house to encourage our officers to accept what has come. Law Society, let's continue together to appreciate this system and change, and together we will enjoy it. What are we doing as a way forward? One of these days you will see, you will be in the marketplace, in the barazas, on the roundabouts, in your churches, you will hear ICMIS being talked about. We are planning, what are we saying? A robust sensitization campaign, so that we reach the common man in Chikuvo, whom we have received feedback is not aware. But it's not that our team is sleeping. We are going to reach the common man to tell them the way to go is ICMIS. I believe you have seen our team on TVs and on radios trying to talk about ICMIS. Whenever you see this, utilize the opportunity to learn more. I've talked about the technical committee that meets every morning to deal with all the feedback that comes. And I want to thank you, President. When you sent me that list with so many issues, it went to the technical committee. In no time, they met you and a couple of other advocates, and they unpacked some of those challenges. So let's continue. I think that is the way to go. So as I sang in the beginning, we have decided to embrace ICMIS, no turning back, no turning back. And just to inform you, this was a heavy investment in terms of money. So in 1 month, we can't give up and shelve it. We only have to put our effort and we all work at it to ensure we attain value for money. And at the end of the day, we enjoy the benefits that the Honourable Minister reminded us about. I think that is it with ICMIS. My Lord, if you'll allow me, I'll just remind members what happens at the kiosk. 3 points. At the kiosk, there are members who help to train and sensitize users. So if you have some time, pass by the kiosk, there will be somebody to assist you. At the kiosk, our staff is able to link and relate an advocate to their old cases. Please go to the kiosk so that they link you to your old case and you move on with the new cases as well. At the kiosk, you can also have the opportunity to give feedback, and that feedback will be relayed to us, we'll relay it to the technical team, and it will be addressed. There at the kiosk, the common man gets an opportunity to have an account created for them, and they're also taught how to use the system, and their manual documents or files are scanned at the kiosk. Madam President, I think I have talked about ICMIS. My Lord, I will deal with a few issues, then my Lord, you will handle the rest. Absenteeism, the lower bench is the biggest culprit in this. I just want to encourage us. They said over 100 comments were about absenteeism. May I request that we bring forth these people? I think the days and times of all of us lamenting about the challenges of the judiciary, we sit in rooms like this, we talk and go, are over. It is time to take action. If you have gone to a court and the magistrate is not there, the chief registrar is in Kampala, is available online, and some of you advocates have called me. I want to thank you, even the president. The issues you have raised with me, we have addressed most of them. Let us expose those who are late, let us expose those who don't come, and we deal with them. I'll tell you an interesting story. One time the inspector set out early in the morning and went and pitched camps in a couple of courts. In one, she sat up to 11, nobody came. In another one, she reached there at 2, there was nobody. There were about 4 or 5, and then she came and wrote a report. So when I asked the members to show cause why they should not be subjected to disciplinary, everybody was sick. That is the day I received the X-ray reports, I received the medical sheets and forms, and I was telling the Honourable Chief Justice and the Principal Judge that we have such a sick bench. Whenever people are absent, then they are sick. We followed on some of them, and some we dealt with them, some we verified they were genuine. The point is, don't sit back and just lament. Bring forth these officers and we take action. Approach the principal judge, approach me, and we will take action on these officers. There is absenteeism that is caused because of training. I must say we have challenges in that area which we are addressing. The Judicial Training Institute is in the process of working out a curriculum, and eventually they are going to come up with a training calendar. This is going to help training be more certain, so that you will all know that perhaps in the month of March, this category of staff will be trained. We are trying to see that we avoid a lot of ad hoc trainings. So it's a matter of time, and some of the absenteeism caused by genuine attendance to other functions or issues like training will be dealt with. But the others, which are as a result of other people's own bad conduct, that one continue to bring them up. Fixing cases at the same time, this is an issue we have addressed with the Honourable Principal Judge in all the inspections that we do. The reason that the officers have given is that in criminal cases, they fix all the cases at the same time because they don't know in which case a witness will come. That is what they have given us. They argue, however, that for civil matters where they know their advocates, they have been scheduling at different times. So I don't know whether this is a challenge, the one that has been raised, whether it is relating to also civil matters, because at least they said for civil, they can give 9, 10, they can progress the day. But for criminal, they will put 20. They don't know which one the state attorney is going to bring a witness. That is their argument. But we have been talking to them, so perhaps you will tell us more whether this is all categories in all courts or specific courts. Because for certain cause lists, we have seen that trend. So perhaps we can be given more information. Land matters and values, I want to encourage all of us to read Section 207 of the Magistrates Court Act in detail, and particularly subsection 3. It will clearly guide us that where you want to determine jurisdiction and court fees, then you need to indicate the value of the subject matter. So I hope that answers that issue. Industrial court, the Honourable Attorney General and the Principal Judge will deal with it. Facilitation of magistrates for locus, it's a big no, because the judiciary is facilitating all locus visits. Every officer is expected to submit a requisition of the locus visits they will be conducting in a given month or quarter, and money is paid from the center. So advocates do not accept to facilitate our officers to do their work. At least we are in better times financially, so we are facilitating all of them, and they have been receiving the money. So I don't know who are those who are still asking for money. When they ask, please draw them to our attention. Providing cars is not necessarily an answer to keeping time, because I believe nobody will say that all those who have cars keep time. So I think it's not. It's more of a character issue which we can deal with. But in terms of cars, this is also work in progress to ensure that the cars are secured for judicial officers to perform their work. Delayed judgments, I wish to inform the advocates that according to our code of conduct, we are supposed to deliver judgments within 60 days. So it's not even 6 months, it is 60 days. So keep track of the 60 days and respond accordingly. If you need to write to the principal judge, please go ahead and do it. Lack of commitment warrants, for me I would request for that list. I think that list gives us a place to start. If you give us a list with the different courts, then we are able to follow up. Research assistants, I think the Honourable PJ will respond to that. Whether that's a useful tool or it has become a liability to us. Transfers without delivering rulings. One of the things in our kitchen is we are working on a handover manual to ensure that we also keep track of this. And if you followed our letters with the principal judge that we write to people who hand over, one of the things we require them to do is to indicate dates of judgment. The issue of judgment or notice, so you don't just write to me and say, I've left this station, I've gone with 20 files pending judgment. You must, within a given time, show me the dates on which you expect to deliver these judgments. I must say our inspections have showed us some serious matters. There are times we have gone out and found that people became judges, and yet they left judgments when they were chief magistrates. And so these are issues that we are dealing with. My Lord, the principal judge, I invite you to handle the rest of the matters. Thank you.
Thank you, Ciara, for your responses. I think the Attorney General raised an important point that we have the habit of ordering that interest be paid from the date of filing, and yet we are the culprits for delaying I think this is a matter we need to look into. That's a genuine concern, really. Perhaps one of the solutions could be that the Court of Appeal, if you have a matter that where that has been done, the Court of Appeal should pronounce itself on that, so that we can. I feel you really. That's not proper. And we are the culprits indeed. I recently decided a matter which was filed in 1990 in land division. So now, from 1990, we have not handled that matter. So I delivered the judgment in 2020. Those are how many years? 30. So if I have to order that, then I go to the date of filing in 1990, surely, I think that's injustice of its own. So I think it's a matter we shall deal with. Then simple rulings not delivered instantly. I think the Attorney General also raised that. I think we intended to. This is a training need. I don't see, for example, a lawyer appearing before you for leave to appear and defend. That's not a decision you should reserve. But I will tell you that I actually had a matter where a magistrate in Mengo, a chief magistrate actually for that matter, reserved ruling on leave to appear and defend for a whole year. And it was being adjourned every month. You go there, ruling not ready. Leave to appear and defend, that's an instantaneous decision. But I think these are training needs. Now, what we want to do is for these new judges we are recruiting, we have been, giving them an induction of 1 month, 1 week, and then we unleash them to the unsuspecting public. This time around, we want to induct them for a month, and where possible, we even give them exams. No, I'm very serious on this. So that by the time they come before the lawyers, they are grilled enough to know that some of these things, they are the ones which cause backlog. I've even seen situations where, I remember when I was in Mbarara, I dealt with matters where I found, there is this common practice of filing interim orders together with, for interim order together with the temporary injunction. Now, the judges a judge would come and handle. By then, of course, we had not amended the rules. So a judge would come and handle the main application, but he has not disposed of the interim order. And the application of interim order remains undecided within our system. So we continue counting it as a pending matter. So these are some of these are training needs, I think, which we need to deal with. Then I think the absenteeism of judicial officers, I think CR dealt with this. I don't need to go on it, but we have introduced a system of uninformed inspections. The other day we were coming from Karamoja, the CR just passed via Katakwi, and found that was around 2, there was no one at the court. So, of course, they didn't know we were coming. We did it, I think, for one of the courts in Western Uganda, where in the morning by 8, our judicial officers were on site. So the chief magistrate arrived at 8:45, and the grade 1 arrived at 9:15, something like that. And all of them had recorded in the register. One of them actually had recorded 8:30, another one 8:35. So then we picked the book and said, now you see you are criminals in your own courts. Eh? So I think the situation is improving greatly. We have visited every court in this country. Myself and Sarah, we know where every court is. There is nothing you are going to tell me that I don't know. We have been in every court, whether it's a sub-county, I know where it is. So now we can decide and say, tomorrow let's visit the Jinja region. And then that's when we call you and ask you, Your Worship, there is something I want. Are you at court? Then you say, yes, I am. Then I say, but I'm seated in your court. So I think we shall solve these problems. The system of precedent disappearing, I think that one was raised by one of the Yeah, I think that's indiscipline of judicial officers. You see, precedent is, this is what I started with. There are certain etiquettes in institutions that you must abide by, whether you agree with them or not. I used the example of security forces. You may have your commander who you know is not even very good, better than you. But as long as he's your commander, you follow. Now, if the Court of Appeal has come up with a decision, there is no reason why the High Court judge should go against it. You can distinguish. You can say, I know they looked at it this way. Maybe they looked at one leg, but they did not look at the other. But you cannot say, I know the Court of Appeal decided this, but I disagree with them. So who are you? That's indiscipline. If we were in the security forces, that would be, I don't know what you call it. Court-martialed, yes. Okay, then there was a matter, I think this was Movende, every judicial officer absent. I think this was raised by one of the lawyers here online. Yeah, that is exactly what we expect. When you go to a court and find the judicial officers are not there, just send a message to me or send a message to the chief registrar so that we deal with it instantly. The other day, there was a lawyer who sent me a WhatsApp message that there was no one at Kasese Court. I immediately sent it to the chief registrar. The chief registrar immediately was able to find out from the judicial officers where they are. That is what we want. You should be our eyes. This is your court. This is your, I told you earlier, this is your garden. There is no reason why you should allow stray goats to come and eat your crops. Don't allow judicial officers to do that. Then judgments in Jinja Court, the judge left with the files. I think I've talked to the judge. I know the problem, and I think it is being handled effectively. I will still need feedback on this. Then, of course, there was an issue. I think this the DPP handled. The one of verification documents. I think this comes under the concept of disclosure, because you also want the DPP to disclose to you, so you also disclose to the DPP. That's the concept of disclosure. Then there was, I think, the issue of DPP staffing. We are handling it holistically together with the Attorney General. We have seen this as a problem, of course. You cannot staff judicially and leave out the other arms, especially the DPP and the Attorney General. So I think this time around we are having a holistic approach, and I think when we are presenting our budget, we want to go with the two offices to the president, so that we iron out this, and we think it will be a thing of the past. There was I think this came from prisons, number of prisoners with no commitment warrants. I think I have received some of the cases. I think I received a list which I passed on to the Registrar High Court to deal with. But some of them, when I tried to deal with them, I discovered that actually there are no judgments on file. I could have handled them myself. But there were no judgments on file. Some judges actually read, someone reads the judgment from the computer and then forgets to print out the copy which should remain on the computer. Now, when they bring these files, it's very difficult for a judge to commit himself on something he has not read, because I could sign all of them. But you see, when you read and then you find there is no judgment, what I've done is to request those judges to make sure that they print out the copies of the judgments, put them on file. And I think we shall sort it out. But give us a comprehensive list, the entire list, as the Chief Registrar requested, so that we deal with it. Then I think there was an issue. This was raised by Kazibwe, that interim orders should be handled by registrars in the Court of Appeal. I think this was a matter that came up, I think, in the court. There is a decision in that respect, that a registrar cannot stay a decision of the judge. So it would raise illegal issues, really. So maybe because that's the reason why the registrars are not doing that. Then there was the issue of research assistants. I think that is indiscipline. Surely, a research assistant, it's not his or her role to write a decision. A research assistant is you are supposed to give assignments to the research assistant on certain areas where you think, maybe you can say, can you get me a decision on this? can you get me a decision on this? But not to write a decision. And then you also state it as a reason for delaying. So maybe we need to summon these research assistants here and understand from them actually. That could be, we think it's an isolated case, it could be cutting across. Okay, and then officials on transfer not delivering judgments. I think we have always emphasized that whenever judges are on transfer, they should not leave a judgment behind. I was transferred in 2 courts. I never left with a single judgment. 1 month, we give them 1 month. In 1 month, you mean, of course, it is a problem that is coming from, from far back. The judge has not been delivering judgments. So, the moment you see a judge with 50 judgments and delivered, you know that one is in dangerous territory. Now, because I have a habit of checking in IKIMIS, sorry, it was then CAS. I checked in CAS, I would spool all these judgments, and I discovered that there were judges who had reserved judgments in 2015 in their commercial court, and they had not delivered them. This was in 2020. And not one judgment. One of them actually had 22 reserved in 2015. I'm not joking. So now, such a person, really, you cannot say it's a problem of transfer. It's a problem of individuals, and I think sooner than later, we will find a solution to this problem. You cannot continue doing that, and then because you are failing on one principle, or the principles we adhere to as judicial officers. So these are problems we'll deal with, I think, going forward. There is I think there was an issue of replacement of a judge in industrial court. I know there is an advert that was run, and the Attorney General maybe would be the right person to give us, since he's an ex-officio on the Judicial Service Commission, he should be able to give us information. But at least I know an advert was run. I know I supervise the industrial court, so I'm aware of the challenge they have. I don't know, Sierra, whether you address the issue of territorial magistrates. So maybe that is, maybe you can share it with the President Uganda Law Society, so that you delimit the jurisdiction properly, so that the lawyers can understand it, and she can share it with them on the website. Now, writing a letter to the Mbare court before getting a hearing date, I can't understand this. Why would you request lawyers to write to you before you give them? Giving a hearing date should be instantaneous. It shouldn't depend on writing a letter. I think I'm going to take it up with the court. Yeah. So now, it's everywhere. Sometimes not only one letter. Okay. Now this is interesting, because I mean, as a judicial officer, you should be able to know the files that are before you every day. Actually, I have been telling judicial officers in our recent meeting which we had, which is quarterly, I told the High Court judges that you should be like prisons. When I visit prisons, you reach at the entrance and the officer salutes and he says, "Today we are unlocked with 500 prisoners, 2 babies, and I want the judges to be like that. When I come to your High Court circuit, you come and tell me, 'My Lord, today I unlocked with 12 cases.' Yeah, you should be knowing the business you have. Now, how can you have cases and you have not fixed them for hearing, and then you are expecting lawyers to write to you? So how about those who don't have lawyers to write? For example, unrepresented litigants. So what do you do? Oh, those litigants whose lawyers have abandoned. So anyway, I think it's good these issues are coming out, and that is the importance of this meeting. So I think Sierra is taking note. So in our next judges meeting, which we are holding quarterly, and then we also have meetings with the magistrates, chief magistrates and magistrates, grade 1 in charge of circuits. We shall deal with these issues. But by and large, advocates, I kindly request you, be keepers of your legal system. Do not suffer in our courts. Do not accept to be mistreated in our courts, because we exist because you exist. If you decided not to come to courts, we have no jobs. It's like, sometimes it's like a doctor, or maybe a person who manufactures coffins. When people are not dying, he has no business. Now, problems in court also make us earn a living. It's the problem in society that you bring in court that keep us in our jobs. So I don't know why you fear to defend your rights within our courts. Okay, let me not say much. Because I was an advocate, sometimes I forget that I'm a judge, then I go the other side. So forgive me. Thank you so much. No, you can do it. Okay, let me go to the CR to address two issues, I think, which you had not discussed. And then, okay, the affidavit of service. I think this is also an individual issue before a judge. This is a judge management issue. Why should you? There are some judges who are actually very anxious to adjourn. I remember when I was an advocate, there was a judge who is retired now. I'm not going to mention his name. Whenever you would appear him and you say, "My lord, I'm not ready." "Oh, no, I think I understand your problems. Let me adjourn for you." Very lazy. He was actually anxious to have matters adjourned. And I'm sure you can know the person I'm talking about. Or even when you came ready to proceed, you would say, "But the counsel, don't you think this is a matter you can settle?" And then you say, "My lord, we have tried, and we cannot settle this." "But no, counsel, try." "Okay, let me adjourn this matter. Come back and report to me in 3 months whether you have not settled." They are there. These are real issues in practice. So I don't see any problem with this issue, really. This is individual judges with problems. Okay, so I think the issue of jurisdiction of magistrates, as I mentioned, the jurisdiction of magistrates courts, I think Sarah will come up with I think there is there is a schedule. We always have a schedule on where these courts start and end. But for avoidance of doubt, let the CR maybe share it with the President of Uganda Law Society so that everyone can know where a jurisdiction starts and where it ends. Thank you so much.
Sorry to come back, but just the issue of jurisdiction, both territorial and also pecuniary, this is work in progress. What are we doing? We are reorganizing magisterial areas. So there's an instrument that is being worked on, especially following the enhancement of numbers of chief magistrates from 100 to 160. So meaning every district having become a magisterial area, there's a new instrument that is going to replace the one of 2017. But beyond that, our field visits have showed us that certain courts were gazetted either wrongly or in the wrong places. We have had situations where you find a court is away from settlement. A court is away from where the people are. So those are issues that a task force is moving all over the country to ensure that the new instrument is going to ensure gazettement is where courts must really be to serve the people. So that is work in progress, and it will come. Relatedly, we all know that in Kampala now, there is no land matter that a grade 1 can handle, for example. All cases, all land is above 20 million or even 50 million for chief magistrate. So that again, the MCA, the proposals are being worked out. Honourable Attorney General is here. In due course, we will be approaching his chambers for the necessary, amendment. Thank you.
Thank you, Chief Registrar and the Principal Judge. There is so much going on. Simon says there's no Chief Magistrate in Palisa, and they are suffering. How can you also help them? That you will receive, Simon, that you will receive one before the end of May. Now that's the purpose of Bar-Bench. Answers come immediately. Simon, you can as well clap your hands wherever you are. because you have got the answer that you were looking for. Those who were, you know, we've just come out of an Easter season. There are people who, when Jesus was crucified, cried and forgot about him and did not wait for the resurrection. So there are people who didn't wait for the resurrection and left the platform before they could receive their answers. We're going to do our best to try and get you as many answers as possible. Madam President, your membership, and on behalf of your membership this side, we want to say that we want another bar bench forum where the members can interact with the judiciary, because there are a lot of things that came up that still need to be addressed and members want to be heard. So we're hoping at least in the next quarter we can have another. And I see the principal judge shaking his head. So members online, you can clap for yourselves, and even members here. Muhindo, you had something to say. Were you addressed? There was a microphone. Okay, but you can shout. You are a man.
All protocols up. My name is James Muhindo, and I'm the current chairperson of the advisory committee of the Network of Public Interest Lawyers. My comment has not expressly been hinted on, which is the attitude or perceived attitude of some members of the bench towards public interest litigation, or lawyers who take on public interest litigation. While it seems like this attitude is towards the messenger, we're taking no cognizance of some of the litigants that may have not been courteous. The message or the interest that is being protected sometimes gets lost in the process. And we've had incidents where members of the bench clearly either speaking to the media or speaking in court, referring to public advocates handling public interest cases as seeking cheap popularity, as doing it for personal gain and not for the cause. But we all know, as we have agreed in all the speeches that have been made, that we as a profession are calling for a bigger cause than ourselves. And most of these public interest cases, it's because the concern is there, the people are, the general public is actually concerned, but there's no one willing to raise the head to take responsibility or to call either an entity or an individual to order. So my request is that the principal judge, if we can if through the discussions you have with the judicial officers, I think by the time people are called to the bench, they are supposed to have a thicker skin than the rest of us. So it's absurd that those we have agreed have a thicker skin than the rest of us are not showing this. So let them be able to be judicious in the way they make remarks, because it's affecting everyone who's working on public interest, and increasingly, especially the younger lawyers are losing interest in this space, and we need lawyers who can stand up and speak when no one is speaking. Thank you.
Thank you. My lord, is the answer. This is noted?
Yes, I guess.
Okay. This is noted. It shall be taken up by the judiciary. Allow me, someone whisper. Please bring the microphone to the head of the bar before I am disbarred.
Yes, thank you very much. Actually, Mr. Muhindo, I'm happy to meet you here. And I think since you have not been to the Attorney General's chambers, you're really not doing public interest litigation. Public interest litigation means you identify a problem. The people who write the laws are in Parliament, they're not in court. You have an Attorney General's chambers. So when you have a problem, you come and raise it. I've seen cases that have been filed in Constitutional Court, and I've come there and said, no notice, no nothing, and I just say, accept, that is okay, they are right. But you've spent money, you've wasted time, and yet we can sit across the table, explain to me what the problem is. If we understand, we read the same law books. So if indeed the provision we are making is unconstitutional, I don't need a judge to tell me. We can come and say, oh yeah, you're right, this is wrong, and we'll deal with it. So I really encourage you to find some time and come and engage with our office. We also have a public interest department because all of ours is public interest. And for the industrial court, yes, we are interviewing on Friday of this week, and we should be done with that soon. Our judicial service, we're also upping our game on discipline of magistrates. I think you've started seeing some activity in that space. So for us, you tell us, we'll deal with it. And then lastly, there's a matter that the President raised, the issue of constitutional court, and then we stay all matters. I've had a conversation with some of our colleagues, and I've said that's very dangerous. Because the next thing I'm going to have is public interest litigants are going to go and say that they are challenging murder. Say we are challenging murder because it's unconstitutional. So because the court process is slow, then we cannot prosecute any murder case until the Constitutional Court has pronounced itself. I think what we need to do is to get the Constitutional Court to move fast on that matter. But we should not stop the implementation of an existing law until it is set aside. So we need to work together, have that matter addressed in court, but I would not advise the DPP or government to stop prosecuting matters because someone has complained. And you know there are so many issues in the Constitutional Court. So that's some balance we need to find, which is neat. The law is there, we must implement it, because otherwise every law will be challenged by someone and we shall end up having no laws to implement. Thank you.
Thank you, Honourable Attorney General. When you stood up, there was a question that had actually come to you, but I chose to withhold it. The question was, is it deliberate for the AG not to serve written statements of defense and responses? And unfortunately, an assistant registrar dismisses an application on such pleadings. Are the judicial officers intimidated by some controversial cases, especially involving land grabbing after creation of private interests? Something about private interests in protected resources. I don't know if that makes sense.
I don't know what case exactly it is, but there is no policy in our office not to file pleadings. In fact, that person should just tell me which case it was, and he will find out what consequence it has. We have a no adjournment policy in the Attorney General's chambers. My Lord, we don't ask for adjournments. If we are asking for an adjournment in court, we write a letter signed by me saying that we are seeking an adjournment of this matter for this reason. Otherwise, we are coming ready to argue every case. So if there are any cases that we have not filed pleadings in the Attorney General's chambers, please share with us. At times, some things may fall off the grid, but that's not our policy. And our policy more is to avoid litigation. And I must tell all the court users, ours is to avoid litigation. If you have a dispute that is brewing with us, you are better off coming to us, having the conversation, because if we are wrong, we shall admit we are wrong and resolve that problem, because it's very expensive for us. We lose a case, we pay costs, we pay interest, we pay damages, and yet we knew we were going to lose the case. So we try to avoid that. So I would really like to know who that person is. We can have a private conversation about it. And if there are any places where we are not appearing as Attorney General's chambers, please feel free to call me anytime. We will deal with that. That one is not, that's a very old thing now. Very old. Thank you.
Michael Collins, I'm sure you've had the Honourable Attorney General. Please do approach the office. We have come to the end. I know there are so many questions. The President is going to look into us having another session. Let me ask Senior Counsel to come and close us off. There is a reason. Now, Senior Counsel, the reason you are here, no, you can come. The reason that he's here is he's the link between the younger and the older. And sometimes, you know, in the African culture, when there's a lot of things happening, the most sound elders come and bring balance. So please welcome Senior Counsel Sebugeni.
Thank you very much. All protocols observed. Ladies and gentlemen, it's quite late, but we've done justice to the Bar-Bench Forum for 2022. Madam President, thank you for giving me the opportunity to close this session. To all of you who have attended, Things have been done in the past. The Bar-Bench Forum came up as an innovation by past presidents, and we thank them for this. And it has grown, it's becoming better. But secondly, I think there's a challenge here to all of us. Who will bail the cat? You will complain, you will say so many things, but the challenge has always been, who will bail the cat? And if you know what I'm talking about, that challenge was on when I was the past president of Uganda Law Society. Sorry, when I was the president. In 2011, in 2013, we said, let's bail one big cat as Uganda Law Society. The principal judge has challenged us, the Attorney General has challenged us, the CR has challenged us. Let's be bold. Let's bold one fat cat. Thank you very much. Have a nice evening, and thank you for attending.
Thank you, Senior Counsel. We're going to take a picture. So I'll ask the Secretariat members to please line the chairs at the front. I know that there were questions to particular heads that we're not able to answer them. We are going to compile those questions and send them to you, to the different heads, but for the judiciary, we'll have another session. Moses and Doreen, I'll ask you to please, you can stand up. You know they can't get the chairs when you're still seated. You can stand up so that they can carry your chairs to the front. I'll ask this table alongside that table to have chairs at the front. This table alongside that table. And then the rest of the members, I'll ask you to stand behind them. Camera, the camera people, I hope you are ready to take the picture. Oh dear. I hope you are ready to take the pictures. So I'll ask the minister, the principal judge, the attorney general, the DPP, the chief registrar to please take your seats at the front alongside the president. The minister, the president, the attorney general, the chief registrar, the DPP to please take your seats. Please take your seats. Okay, this is what it means to have protocol. Okay, is the DPP seated? All right. There is one person. Who is the one person? Okay. Can I ask all the registrars to please come, the chief magistrate to please come and stand behind. Members of the bar, please come. This may be your only picture in a long while. Please come. Please come and stand. Please come and stand at the back. Okay. Okay, okay. No. Hold it. Wait, Mr. Chivumbi, they are asking you to come and sit. I think the CID. Camera, do you have everyone? Okay, first wait until I'm in the picture. Okay. Thank you so much. Thank you again. We've come to the end. This is the point we'll members online that are still online, thank you so much. There are 225 members still online. Thank you so much. We are going to share those questions with the judiciary, with the DPP, with the Attorney General, with the prisons and police, and we shall respond to you. Allow me now close. You can close the members online. Thank you so much. We see your comments. We shall make a follow-up discussion for you. We shall make a follow-up discussion so that we can have further engagement. Thank you again. God bless you and have a lovely night.